May please your lordship. And I would like to mention on IA in one writ petition relating to land acquisition matter pertaining to bench 5, your lord.
You want it for listing?
Yes, your lordship. Much obliged. May I please your lordship? With the consent of other side, I beg to mention item 23 of supplementary list. It may be taken up on next week on any other date, lordship.
You have taken the consent.
Yes, lordship.
Item 23, listed after 1 week.
Much obliged.
My lord, I'm praying for listing of a fresh petition, my lord. 12 villages have been transferred to Morigaon district from Kamrup Metro district. Now, my lord, administratively, they are under Kamrup Metro and
Monday.
Monday. Maybe tomorrow.
Much obliged. May I please, lordship?
Yes,
Lordship, I'd like to mention item number 15. Item number 15.
15. Yes.
Council, Mr. A.K. Burkashta is on leave, and the other council, Mr.
Have you informed the other side?
Other side, respondent council D. Nandi has been informed.
You have informed. We have informed whom?
Respondent council for respondent number 10 to 15, D. Nandi.
That- yeah. Okay. Item 15 at the request of 15. Item 15 of the request made on behalf of Mr. A.K. Purkach, matters has been heard. Be listed after 2 weeks. It's submitted that consent of the council for the respondents have also been okay. But this 2015 matter,
So
where is he? Where is he?
he's on leave, and other council he's unwell.
No, you ask him to come back on, this is a 2015 matter. We can't just adjourn like that. We'll have it on, 12th of December. Sorry, sir, not 12th. 10th of December.
Oh, okay. Apologize.
10th of December.
May I please your lordship? I want to mention item number 14 of the daily list. My senior Mr. Ekeda's name is there. So from WPC number
Item
586.
listed before any other bid without.
Obliged.
What is your lordship? Let to mention for listing tomorrow, lordship, because similar matters are pending before your lordship tomorrow. Delimitation matter.
But what is this matter?
Delimitation matters of panchayat, lordship. There is a series listed before your lordship tomorrow.
That's okay. Your matter will come on Monday. Why do you want it tomorrow? Fresh matter.
I filed yesterday, lordship.
Let it be on Monday.
Yes, your lordship, please.
Monday.
My lord, in this case, my lord, I am appearing for 6, 7, and 6, 7, 8, and 9, but my name has not been shown in the cause list also.
But you are here.
Yes.
Without your name being shown, you are before the court.
Now, I presume
No
he is
problem,
not seeking for an adjournment.
All right.
If he's praying for an adjournment, that's fine with me.
No, actually, I was newly implemented.
No.
That is why.
So what is your prayer today?
Let him.
No, Manoj, I should be fair. A while back, we had a discussion that there's another matter pending in the review, which is a little late in the day. We would consent and get things sorted out. But now he's objecting to that,
No,
residing
I'm
on
not
his own
objecting.
thing. Like that's off the record, though. Then we'll go ahead in different way, Manoj.
No, this is a review matter.
No, this is a petition.
Huh?
The sum and substance is
The order which has been tagged, my lord, it is in the review order. But along with this review, this writ petition has came. Now it has been bifurcated.
Okay. What
That
is
is why it is.
what I am on is that, Manoj, this writ petition can be disposed of. The review which is pending in the court of the day, when I make a statement at the bar, I mean by that, Manoj, he also has, of course, agreeing to that, with the board being there. We can all settle the issues up. Now, if they're residing on the count that his name is not being shown, fair enough with that, Manoj, then let the matter be adjourned for 4 weeks, Manoj, indicating his name.
What is the issue involved here?
Issue involved here, Milord, is that there was a complaint by my client concerning some boundary construction, etc., on the neighbor's side, to the authorities of the municipal board, deputy commissioner, etc. They having sat over the matter, we came to this honorable court. Now in this honorable court, a gentleman on the other side was arranged as a private respondent. When the matter was being heard, his counsel made a submission to a pointed query put by the court that said that I have no rights. It was my late wife's property. I have no right. So his name was struck off from the array of parties recording this. And direction was given to the executive officer to take a call on the representation with the time period so done. Now, executive officer, this was a writ petition A. A is gone. Now the executive officer concerned, or the authorities concerned, issued notices to this gentleman also, whose name was struck out. We told that this is nothing doing, his name was struck out. We had to come in next writ petition B. Honorable court stayed the proceedings, but he again continued. We filed a contempt. Contempt is C. I'm coming to that, my lord.
Yes.
Now, during the pendency of B and C, A was disposed. Pendency of writ petition and contempt, the authorities issued an order of demolition. That was 30th of August. We produced it in the court. Accordingly, B and C were closed.
So demolition of
The other side.
other side.
We produced it in the court. So the B and C were closed. The writ petition and the contempt were closed. Now we represent to them. Now we could come to know that on the day it was demolition order was issued, and when we placed on the 1st of September and the 20th of September, prior to that, they had withdrawn that order, recalled that order. But they had been silent to the court.
By the municipal,
By the board.
by the board.
By the board. They had a resolution adopted, and it was not placed before the court by the executive officer concerned who had issued the demolition order. But this gave the birth to this writ petition. We say, my representation is pending before you to take a call this way, that way, whatever you do. And your tight-lipped behavior was a willful and deliberate attempt to mislead the court. We're praying for suo motu issue, drawing up of contempt proceedings. Because if you had said so, that no, that demolition order has been withdrawn, I think would have happened. The writ petition would have continued, traveled a bit further, and an order would have been passed correctly so. So, my lord, if
Against that was any review filed? on
no
the-
review
My lord-
was filed, just a moment.
My lord,
Re-
one thing, my lord, may I point out one thing? Against the original order, there was neither a board party nor there was any direction as per section 177 of the Municipal Act. So board was not party. Then I immediately filed a review application within time. In the review application, 2 points I have raised. One is the order direction which has been issued to the executive officer is not the authority. Under the law, board is the authority. And number two, the name of the father which has been struck off. It is on affidavit in opposition. I have stated that I am the one of the legal heirs. I am inherited the property. But whatever be the reason, my lord, this has been not came into the knowledge of the honorable court, and name has been struck off. Whatever be the reason, then on these two grounds, I have filed review application, and review is pending, and review is to be decided today itself.
Anyways, my lord,
And this is the sum and substance. So under such circumstances, in review application, my contention is that if the direction is given to the board, then I don't have any objection, because as per law, board is the authority, because there is an alleged violation of the construction by me as well as by them also. There is another writ petition. There is the violation against them also. It is not that cross-claim, of both the parties. So it is
But I was
purely
not on
a
that.
civil dispute.
he has gone
because-
to the review. I have not even gone to the review. I was thinking of covering things up so that things can be closed down. He's arguing. I'm surprised by that. Anyways, my lord,
Why are you surprised? These are-
because
Is-
no, I'm taking
I
the
have
surprise.
point out the real
taking the
fact.
surprise.
That is why he is surprised.
I was taking the surprise. Well, a while back he said, all right, we'll close it up this way. So I was on a different
Unless you
note.
want to say you are not arguing but submitting.
Absolutely. I'm placing the fact. No, I'm not even going a bit further. So what would be a peaceful way to cover up this thing?
Can't help it because they keep on coming. It will be a sad day if lawyers stop.
I understand. I fall back on that. So
Right.
this writ petition
Right.
was mainly on the anguish that why B and C had to be closed because of your tightly behavior. Therefore, not his. Therefore, it calls for a suo motu contempt, as well as my main prayer that the board you take a call on my representation, whatever you do. In my review, I make a stand, Miller. I'll go forward, say that whatever happened with that father, let him come in, let the board decide, regardless of board being party or not. But if he is raising an objection on the arraying of parties, then of course we have to argue on that.
So in this writ petition, the only question is essentially is to issue a direction to dispose of your representation.
Essentially, and the other part,
Contempt.
contempt suo, because if they would have not said so, my proceedings would not have been withdrawn.
Therefore, why don't you file an application before the court? Because the
Wait,
contempt
I am
petition was
not on
there.
that today. I am not on that today.
Ah.
I was wrapping things up.
So as on today, this prayer
I'm not on
B,
that.
prayer B is not there.
No.
All right. So only prayer A.
My lordship.
Who's for the board?
And Chairman. My lord, the first case filed by the this petitioner.
No, as I see the prayers, the limited prayer is for a disposal of the representation, unless you say it has already been disposed of.
It's not yet.
So you dispose it off.
Yeah.
And he does not wish to press the second prayer
I'm not pressing the second.
for contempt.
So this would not be against him also. Their stand can be made clear in their reply to that representation, whatever they.
No, dispute is actually in the representation, alleged violation has been done by me.
No. So
Hmm.
therefore,
So it
while they pass an order,
Yes,
Absolutely.
will give an opportunity of being heard to both parties.
including my father,
No, that will agree there. I said I'll agree there.
including my father.
When the
Because
review is called up, I'll agree.
after death of wife, father is also one
That
of the
That was
one
the
of the
obvious
party
thing,
in this.
Whoever is on the basis of the
Yes.
documents available, whoever is the owner of the property,
Yes,
be given an opportunity.
as per law, who is who are entitled or who are inherited.
You are what? You are the daughter or son.
Sons,
You are
sons
the
and
son.
daughters.
You are arrayed here as respondent
6, 7, 8, and 9.
in this petition. Okay.
No, after implementation.
I'll make it slightly different, Miller.
Hmm.
Lordship may put it this way, subject to my lord's convenience and what my colleague would say, that in this case, the sons and daughters are represented by Mr. X, by my colleague. And down in the day before that honorable court, put number 6, item number so and so, the review is there where here I make a stand as a counsel that I'll agree to that the father will be arraigned as a party. That's all.
We can't record this that you will agree before that.
Yeah.
No, I am making a submission before this
So
court.
what
Miller.
we want to say is this 6, 7, 8 and 9 are the children
Are the children.
of the original owner.
Mother, yes.
The
Original
original
owner was
owner
mother.
was the mother, she expired.
No, mother.
Mother.
Who expired?
Mother expired.
That's right. So who was the owner of the property?
Now, after death of mother, is her husband, that is father of this four.
That's what we are saying.
Yes.
The owner was the wife.
Owner was the wife.
She died.
She died.
So therefore the legal heirs would be the spouse as well as the children.
Yes.
Now the children are arrayed here.
Here.
The father is not here.
Not here.
All right.
The hearing of the father was declined on the count on an IA because the review was pending.
Whatever it is.
Whatever it is.
My lord, just one thing. There is another writ petition which is fixed tomorrow probably.
That's a different issue, not from the same topic.
Let me submit. There is another writ petition filed by the son of the
Son.
respondent number
We,
that my friend is representing. There also the petitioner hearing is a respondent, and they allege violation of
The respondent.
respondent side. So there is two complaints from both the sides.
So you dispose it off.
Both the
No.
That's tomorrow.
We are closing this petition. So in terms of the prayers made here,
Yes.
you dispose of, you close the representation. And if there is
Otherwise,
another
if there is-
representation pending,
yes.
uh,
I was just wondering if there is two orders. either from this court that this representation
No.
is represented.
Supposing there is no order, then also under the provisions of law, you are required to address somebody's grievance.
Exactly.
Now, this petition is closed, this petition before the court because there is no order passed here.
Yes.
That's the only issue. Heard Mr. S. Bonik, learned counsel for the petitioner, Mr. A. Dhor, appearing for respondents number
3 and 5.
3 and 5. So who is for 1? Karimganj Municipal. You are also there. You are representing. Executive officer.
1 and 2,
Okay. 1 and 2, Mr. N. Goswami. Mr. He's the executive officer. All right. 1 and 2. He's there, number 5. You are representing the chairman. You are for 4, executive officer. All right, then you represent number 2 and 4. And Mr. Goswami represents 1, 3, and 5.
No, my lord. The entire problem is that because the municipal board has been arranged by represented by the executive officer.
It should
Whereas
be
it
by
should
the
be chairman.
chairman.
The entire problem started from there, man. In presence,
Whatever it may be.
One is representing by Dhar.
Hmm. One,
Karimganj Municipal Board,
1, 2, and
not 2.
not two,
1 and 3.
1, 3, 5.
okay, 1, 3, 5 by Mr. Dhor. 2 and 4 by Mr. Nath. And Mr. N. Goswami for number 2. This Mr. You are appearing for 4, 5, 6, and 7. No,
I
sorry,
am
6, 7, and 8.
6, 7, 8, and 9.
Mr. Ghosh for 6, 7, 8, and 9. Stop this. The writ petition is directed against seeking an order from this court to the respondent Karimganj Municipal Board and its chairman and executive to pass final orders on a representation dated 4/10/2023.
My lord, may I point out one thing? Representation submitted before the executive officer, it should be submitted before the chairman or board. Because there was the problem.
Is there a problem for the executive
Yes.
officer to send it to the
At that point
chairman?
of time, there was a problem. That is why this all this case has come out.
All right.
That is why by name he was made party also in this case.
Representation dated 4/10/2023 filed before the Karimganj Municipal Board. So the grievance originated by raising a complaint in respect of a construction carried on by the private respondents who are neighbors of the writ petitioner. Stop. The
Predecessor of the private respondent.
Hmm?
Predecessor of the private.
predecessor of the private respondents was the neighbor of the writ petitioner. Stop. The schedule of land as reflected in the writ petition. This Sanjay Kumar Dam, who is the power of attorney holder,
Lordship.
represents the private respondent.
No.
Then
Private respondents are the sons and daughters of the owner on the other side.
You know, where is the schedule of the land? This schedule of the land in para 6 is for what?
My lordships. Para 6 is the land, schedule of the land, which, my lord, they are representing.
Okay,
They are
you are the
coming
power of attorney holder of Sanjay Dap.
my
All right. The grievance is that the predecessor of the private respondents constructed a plot of land in a manner that it affected.
My lord, dam is the represented by the petitioner.
Right.
Power of attorney of the writ petitioner, not our.
uh, Affecting the northern boundary wall of the land of one Sri Sanjay Kumar Dam, who is the brother of the petitioner.
Yeah.
And stop. The petitioner is the power of attorney holder of the said Sanjay Kumar Dam. Stop. Aggrieved by the manner in which the construction proceeded, petitioner approached the authorities by filing a complaint dated 22/11/2021, bringing it to the notice of the authority about the construction being carried on in violation of the rules and procedures. Stop. The complaints were complaint dated 22/11/2021 was lodged by the petitioner and marked to the executive officer, Karimganj Municipality, the TC Karimganj and the circle officer Karimganj, praying for appropriate orders. Stop. However, since no action was forthcoming, the petitioner approached this court by filing WPC 1749 of 2022, seeking a direction to the official respondents to take immediate action on the complaint dated 22/11/2021. Stop. In the said writ petition, one Sri Gobindo Dev was arrayed as a private respondent. Stop. However, during the proceedings of that writ petition, on a query, on a submission recorded on behalf of the respondent that the said Sri Gobindo Dev was not the owner of the property, and the owner of the property was his deceased wife. The court, by order dated 20/01/2023, was pleased to strike off the name of Sri Gobindo Dev from the array of respondents. Stop. The court what was the direction of the court disposing of the order?
The first one, page 32,
It's court
or maybe at page 34.
by the said by order dated 20/01/2023. Disposed of the writ petition. Permitting the petitioner the liberty to file a representation before the executive officer, Karimganj Municipality Board, for examining the grievance of the petitioner, which was previously raised by his complaint dated 22/11/2021. Stop. On the representation being filed as directed within 10 days from the date of that order, the executive officer of Karimganj Municipality Board was directed to hear the petitioner and the owner of the said construction carried on by the neighbor of the petitioner and dispose of the representation within a period of 6 weeks from the date of receipt of a certified copy of this order. Parent. Pursuant to the direction of this court, the petitioner filed a representation dated 18/2/2023, which was received by the concerned office. Stop. When the notice, upon receipt of the representation, the municipality board, Karimganj Municipality Board, issued notices to the petitioner as well as to the said Sri Govinda Dev, being the owner of the said property. Stop. This was objected to by the petitioner on the ground that the said Sri Govinda Dev's name was struck off from the writ petition number 1749 of 2022 by the court on a submission made by on behalf of Mr. Dev that he was not the owner of the party, and consequently there is no necessity to for the presence of Mr. Presence of Sri Dev in the hearing of the matter to be conducted by the executive officer. Stop. However, the on the authority insisting on issuing a notice to the said Sri Govinda Dev, petitioner approached this court again by filing WPC 2405 of 2023. Stop. What is this communication 26/4?
By this, the authorities had issued notice to Mr. Dev as well.
This court, while issuing notice, this court by order dated
That's at page 44.
4/5/2023. While issuing notice, directed that the communication issued by the Karimganj Municipal Board dated 26/04/2023 shall not be acted upon. Stop. Where is that order? 4/5/23. 4/5/23.
26/4. What you referring?
No. The order of the court. Subsequent order
Subsequent order of the board for demolition, Miller.
of the court.
46, page
46. 46.
However, the Karimganj Municipality Authority proceeded to proceeded with the matter by issuing communication dated 10/5/2023 to the sons and daughters of the predecessor, sons and daughters of the owner of the property, late Subharani Das, wife of Govinda Dev, asking them to produce all necessary documents. Stop. The sons and daughters are arrayed as private respondents 6 to 9. 6 to 9. Stop. The petitioner being aggrieved by the Silchar Karimganj Municipal Authority carrying on with the proceedings, he filed a contempt petition being on case number 441 of 2023. Stop during the continuance of the proceedings in WPC 2405 of 2023 and contempt case number 441 of 2023. A notice dated 3008-2023 came to be issued by the Karimganj Municipal Board by exercising jurisdiction under Section 177 of some Municipal Act 1956, directing the present private respondents to demolish the deviated portion constructed, deviated/unauthorized portion constructed within 30 days. Stop. Pursuant to the issuance of the notice of demolition, which was produced before the court, the WPC 2405 and 2020/2023 and contempt petition number 441 were both closed. However, in terms of the order of demolition issued by the Karimganj Municipal Board dated 3008-2023, no steps were taken by the owners of that building to demolish the portion which was deviated or unauthorized.
My lord,
Stop.
order was not passed by board,
This is what is pleaded.
by the executive officer.
No, this is what is pleaded.
Oh, pleaded.
Recording.
The it is submitted before the court that pursuant to the order passed, petitioner came to be aware that this order stated to have been issued by the executive officer, Karimganj Municipal Board, was withdrawn prior to the date. Was withdrawn by whom? By the board.
By the board by resolutions on 192023.
I have the resolution.
By the board, Karimganj Municipal Board on 1/9/2023, and which was never brought to the notice of the court
By the executive officer concerned.
by the executive officer concerned at the time when this court was in session of the matters, and the order dated
19 and 29.
when was the writ petition and is
20th of
20
September and 1st
20
of September.
1/9/2023 and 20/09/2023. The contempt case and the writ petition respectively stood closed. Stop. It is submitted that by the said order dated 1/9/2023, the Karimganj Municipal Board in its meeting held that the notice dated 3008-2023 issued by the executive engineer was declared to be null and void. Stop. Para. The present writ petition is filed, being aggrieved by the inaction of the Karimganj Municipal Board that, notwithstanding the decision taken by the Karimganj Municipal Board on 1/9/2023, holding, declaring the order, the notice dated 3008-2023, which was declared to be null and void. 3008-2023 issued by the executive engineer to be executive officer of the board to be null and void. No steps have been taken to redress the grievance of the petitioner and pass appropriate orders thereon. The present writ petition therefore is filed by the petitioner seeking a direction to dispose of his representation dated 4/10/2023. on the basis of the material available before the municipal court. Stop. The further prayer is to draw up suo motu contempt proceedings against the private respondent for willful suppression and willful suppression of facts and violation of willful suppression of facts, and thereby ensuring the closure of WPC number 2405 of 2023 and contempt case number 441 of 2023. Stop. The learned counsel for the petitioner, however, has submitted that at present he has instructions not to press the prayer made for drawing up suo motu contempt against the respondents. He submits that the writ petition can be closed with a direction to the municipality board, Karimganj Municipality Board, to pass appropriate orders on the representation dated 4/10/2023, filed by the petitioner. Stop. Para. Learned counsels for the parties have been represented by the respective councils, and no counter affidavit has been filed by the parties. What is your submission for the council?
My submission is that, my lord, if representation is, direction is given for disposal of the representation, all the legal years of the original owner be heard. And number two, my lord,
But there is a judicial order saying that your father is not the owner,
that is why review is pending, my lord. That,
subject to such orders being passed by the review board. There is
but,
an order.
my lord, by the judicial order, can an ownership of an inherited property can be wiped
But
out?
the judicial order is to be complied with. If not complied, it has to be corrected.
Judicial order, that review is pending, and judicial order is with respect to that the name of the that they may be struck off. It is not that he is not the owner, nothing.
There is a submission, there is a fine.
Submission, but no finding that with respect to that.
All right, then municipality board.
And under section 177, the direction which has been given to the executive officer, that should be given to the board. Because there is a provision.
No, but there is no direction sought in this petition to the executive officer. It is to the respondent. Now, under the provisions, if it is the municipality board who
Board,
has to
yes.
decide,
Yes,
we'll issue a direction to them
to them, yes.
to dispose of and pass appropriate
But
order.
earlier proceedings were only against the municipality board represented by executive officer. Chairman was not made a party.
Not municipal board. Municipal board was not party.
Municipal board was also not a party. 1749 manner. 32.
No, but if the executive officer was made a party, executive officer being directed, does it, is a specific direction necessary against the municipality board?
My lord,
My lord, kindly see 177.
what do
177.
you say?
Even municipal board was also not party.
No.
Kindly see 177, because here in this case, alleged violation of sanction granted. So it is specific power has been given under section 170, power of the board in case of disobedience should building by so and so materially alter or erect. Neither board was party, nor the chairman was also party.
All right. The respective councils appearing for the respondents submit that the power to consider and pass appropriate orders in respect of any unauthorized or deviation in respect of constructions made pursuant to sanctions granted by the municipality board is vested only with the municipality board as per section 177 of the Assam Municipal Act. Stop. The council appearing for the respondents, private respondent submits that if a direction is issued to the municipal board, then the right of hearing in respect of all affected parties should also be permitted. So, better. Learned councils have been heard. The writ petition and the enclosures have been perused, as well as the provisions of so and so act. The limited prayer of the writ petition is seeking a disposal of a representation preferred. Where is your representation of which you are seeking disposal?
My lordship, page 56.
The representation dated 4/10/2023. Stop. A perusal of the representation reflects that it is addressed to the executive officer, Karimganj Municipal Board. Stop. Under section
177.
177, the power is vested on the board to pass appropriate orders in respect of any violation or deviation of sanction granted in respect of constructions of buildings or erection of structures. Stop. This representation has been duly received in the office of the executive officer, Karimganj Municipal Board. Stop. By communication dated 19/10/2023. This communication has already been brought to the notice of the chairman, Karimganj Municipal Board. Stop. Therefore, the representation filed by the petitioner, although addressed to the Karimganj Executive Officer, Karimganj Municipal Board, has also been placed before the chairman, Karimganj Municipal Board. Stop. Under such circumstances, since the power is vested on the municipal board, this court considers it appropriate to close the writ petition at this stage with a specific direction to the municipal board, Karimganj, to look into the grievances raised by the petitioner by way of his representation dated 4/10/2023, and which have been forwarded to the chairman, Karimganj Municipal Board, by the executive officer by communication dated 19 October 2023. Stop. The board will hear all the affected parties and examine the relevant documents, call for reports if required, and thereafter pass appropriate orders on the said representation. So, since the councils are already represented, we direct the petitioner as well as the private respondents to appear before the municipal board on 16th December.
November, December,
16 December,
right, sir?
so that the municipal board can forthwith proceed for hearing in the matter. The municipal board will endeavor to dispose of the representation as early as possible, but not later than how much time you require? 30 days? 30 days from the date the parties appear before the
16.
municipal board as directed, which is 16. And parties appear before municipal board directed on 16 and present a certified copy of the order. And 30 days would be 16th of January.
January.
Are there any holidays?
Yes.
45 days. 45 days from
From 16th of
16th.
December.
Huh?
45 days from 16th of
16th of December.
December.
With the above observation, writ petition stands disposed of. No order is proposed.
Grateful, my lord. Obliged.
In fact, let's try to order timely.
Lord, item 20 and 21, in both these matters, we want to withdraw the cases with the liberty to approach the Assam Board of Revenue, my lord. We wish to see that the content jurisdiction is there.
Mr. S. D, learned counsel for the petitioner, submits on instructions that the petitioner does not wish to press the writ petition any further. Instead, they would like to approach the Assam Board of Revenue
Revenue, my lord.
for redressal of their grievances. Prayer is not objected to by Mr. Hendig, counsel representing the Revenue Department. MS L. Gogoi appearing on behalf of C. Borua for the NHIDCL. The writ petition accordingly dismissed as not pressed. Interim orders, if any, stand vacated. This is item number 20 and
21.
And?
21.
21. Similar orders.
Liberty granted
For
approaching the.
we have liberty granted.
Much obliged.
All right.
My lord, in this matter, my lord, Learned Deputy SJ is appearing, my lord. There is some confusion, my lord. There's two similar matters by same name, my lord. In one matter, my lord, I am appearing, my lord. In other one, my lord, the Learned Deputy SJ is appearing.
This is
Lord,
appointment of arbitrator.
Yes.
Railway contract.
Yes, my lord. Yes.
That clause 64 or 65, whatever that is.
Yes, 63,
When is the other matter fixed? Yesterday we had dealt with a matter.
on 3rd, my lord.
3rd of December.
Yes.
We'll have it on 3rd.
My lord. My lord.
Let the matter be listed on 3rd as similar other matters are listed on the same date. R. Hussain for the petitioner, Mr. H. Gupta for the response.
Obliged.
Obliged.
Well, here the issue is very serious, my lord. The names of this petitioner and the, as per the agreed person, annexure 1, my lord, in the process of Assam Mala road construction, my lord, in the Dima Hasao district, my lord, your lordship will find that, my lord, the numbers of the villagers' land has been, my lord, forcefully taken without following the Right to Fair Compensation Act or any other, my lord, law as per the state government. My lord. Now, this revenue secretary, my lord, of the NC Hill, my lord, they have constituted a committee, my lord. From the affidavit, my later on, they inform us that there is a district level land policy committee, land purchase committee, say in the form of a direct purchase. Now that land purchase committee did not adhere to any of the statutory provisions as per the notification they have mentioned in the affidavit, my lord. And from January 2024, my lord, sum and substance, my lord, from January 2024, they have rampantly, my lord, forcefully one after the other, they have been, my lord, taking away the lands of these ST Hills, my lord, Lima also community. My lord, they are, my lord, in every occasion, my lord, they try to, my lord, delay the matter. In the meantime, my lord, we have to face the, my lord, the problem.
Affidavits not exchanged.
Everything exchanged, my lord. There is an order, my lord, by this honorable court, my lord, 21-8, my lord.
Lordship, I am
Readings are complete.
seeking an adjournment today, Lordship.
Why?
Lordship, Mr. R.M. Das will address this matter. He is out of station, Lordship.
Now, on 21-8-24, pleadings was exchanged when both the parties are present, my lord. Thing is that, my lord, considering the urgency, court wanted to dispose of, my lord, the matter. And the issue is confined to, my lord, the policy adopted, my lord. I have the book, my lord, Direct Purchase Policy Act. So, my lord, apparently not a single the notification provided the procedure, my lord, for negotiated settlement. Nothing has been followed, my lord. Therefore, they are delaying, my lord. One pretext or other.
Who represents the revenue? The
Revenue
secretary revenue.
We represent.
You represent. Now, when is Mr. Das coming back?
Lordship, any day next week, Lordship.
Yesterday
So
also,
why their money has not been settled and disbursed?
because there were no negotiated settlement, my lord, they have not adhered to any settlement procedure as per government notification. They on their own, my lord, adopted a method, my lord. That method is very, my lord, surprising. So I have the notification also, lordship.
What notification?
The notification may I place your lordship, which they have referred, my lord. The NCs are referred, my lord, later on in the affidavit in notification. May I place your lordship, dated 20 January 2021. At my lord, paragraph number 4, my lord.
Oh, it can't be read properly.
Yes, my lord.
Then-
I have downloaded, my lord. They have not provided copy, my lord.
Don't tell me that there are no better copies available. It's available somewhere.
My lord, I will type out, my lord. This too.
Please type out and get a better.
But your lordship, well, the thing is that considering urgency, your lordship may, if inclined to take it up on 3rd December, my lord.
Oh, any matter.
Thank you. Thank you, my lord.
Otherwise, my lord, they are rampantly doing this, my lord. Yesterday also they are doing it at
5th of December.
Lordship. Can it be on 10th, Lordship?
my lord, 5th is necessary, my lord. Okay.
10 December, all right, 10th. At the request of Mr. T. Sarma,
Yes.
council representing NH, what is that?
Lima South.
Lima Hasao.
Lima South.
Lima Hasao Autonomous Council. That the arguing council, Mr. R.M. Das, was the standing council, is our station. He seeks accommodation in the matter. Stop Mr. P. Porwal, the counsel for the petitioner, expresses urgency in the matter and prays for a fixed date. He has agreed to by the council for the parties based on 10th December. You are appearing, Mr. Nath?
I'm for 1 and
Mr. Nath, D. Nath, Senior Government Advocate Assam, appears to respond to 1 and 5.
God bless you.
number 5.
Lordship may take up the matter after some time.
There is absolutely no problem. Whether, as per direction passed by this court, whether your lordship the recollect, that's regarding about a contract work. I just don't want that your lordship just will proceed. End of the day, they will say this is what. If they really have cancelled the approved drawing which was given to me, then then I have to bring it by way notice. Kindly see the order that was passed by this court.
That causeway,
Causeway, right. My lord, your lordship does recollect, a contract work was given to us about
so
amounting
this is
6
something
crore.
additional.
That was approved. Accordingly, on basis of approval, we have done 70% of the work. They paid the amount to us, was a 1 crore. And it is admission. My lord, I have brought notice to because the admission also from their side. When the meeting was held, chief engineer said, hold a meeting. In the meeting also, there is a comparative statement. We see the comparative assessment, they have stated themselves, causeway has been done, it has been approved. Now, after that, on 6/5/2024, they filed an affidavit. And in that affidavit, they said, no, the approval which was given to him, we have cancelled. Now, your lordship wanted to know and see, produce the record where that it was really cancelled or not. Suppose they produce it, then your lordship will definitely ask that this is the cancellation. What do you do? Whatever. That's why whether that record is available or not.
Yes.
That's important, Mike.
Lordship,
If it is not available, then on a next day they should produce that record.
Lordship, we have a few documents. Let my senior.
All right. After some time.
No, it's okay.
আমার তো নতুন করে ফাইল করে
Very nice.
ফাইল করেছো
Bulbul. Yes.
Please do it. My lord,
Readings
was a-
are exchanged? Readings complete?
all change.
Yes.
My lord, at page 42, I'll just briefly, my lord, before your lordship opens up the file, I'll just tell what is about the case and why we approach this honorable court. Your lordship knows that in the state of Assam, in lot of other states, there's some traditional culture where in state, in the month of January, they held a buffalo fight. Buffalo fight in the month of January. Normally it is 15th of January till 25th of January, that time. And also a bulbuli fight. Now this was going on for a pretty long time. Then, my lord, there was certain repentation or written that how this fight, this is total violation of the provision under Wildlife Protection Act, then Prevention of Cruelty Animal Act, you cannot hold it. So ultimately, my lord, there are some other states of Maharashtra, state of Tamil Nadu, state of Tamil Nadu, Karnataka, those three, there were fights which was that Jalakattu fight, Bullock cart race, all these races going on. So ultimately, it went to the apex court. Same people for animal treatment, they filed, and ultimately the apex court in 2014, in an Agra judgment, they held that no, this is totally in violation of the provision of the Prevention of the Cruelty of Animal Act and also Wildlife Protection Act. This is, you cannot go do this. So ultimately, there is a ban of this particular race to be conducted. So now, my lord, in that view of the matter, in our state, my lord, there is no act. In those three states, there was act, but that act was not in consonance with the central act. Now, court said you can't do it. It is absolutely illegal. How can it be a Nagra judgment? So there was an order that there was a ban.
There was a challenge to the
There-
various of those acts,
Those acts.
state act.
Those act, those act in the state act. Now I know there was a ban. Entire state, India, it was banned. So that ban was communicated by WT message in the state of Assam also. In somewhere in 2000, after judgment 2015. So now 2015. So now, my lord, there was an order passed by the court, some writ petition was moved. There was an order passed by this court, and they said, as there is an order passed by the Supreme Court, that ban remains. So you cannot hold it. any fight. So that is the position. In the meantime, what has happened in the state? The state decided no, a cabinet will decide by way of cabinet decision, will take certain decision. So that particular went ahead, my lord, and the cabinet had taken a decision, and an SOP has been issued in the year in 27 of December 2023. Now, this cabinet decision has been put to challenge. Now, the three particular states where specifically there was an act, subsequently, my lord, they amended the act which they prevailed. These three acts, they have amended the act, which it was in consonant with the Central Act. Now, that was placed before a constitutional bench in 2023. It was heard by the judges, and the constitutional bench has now hold that no, they have filled up the gap, lacuna. So they have taken the assent of the president also. In that view of the matter, there is nothing irregularity because of the amendment of the act. So in that way, they have permitted, but with certain restrictions. Now, we heard, my lord, challenge the 27th of December 2023. That is the SOP which has been issued by the state government. And we say that in this state, you don't have an act, neither there is you don't have an act also. You relied on a central act. So when there is a central act, and total it is in violation, because you cannot held any fight, this type of fight, it is banned, and that judgment of in Agras follows. So in that view of the matter, my lord, we came a bit late in the 2023 when this SOP was issued, 27 of December 2023. We came a bit of late in the month of January, when almost the fight was over. One fight, 24th or 25th, 25th we came. Now, my lord, after that, there is why I'm saying there's a background. After that, my lord, different districts like Morigao, Nagaon, they were holding some buffalo fight. And this SOP said, you cannot hold an SOP, as per SOP, you cannot hold any fight beyond 25th. So now we put notice to the court. We brought notice to the court. This is what they were trying to do it. There was some protection which, after investigation, that is correct, they were holding it. There's some FIR which was lodged. We came up before this court also. Court said, no, we have to comply with that. Now, end of the day, my lord, the matter came up. Last 2-3 times the matter came up, my lord. They have not filed any reply. Parawise reply they have not filed any to our contention. They have filed a general affidavit. Now, my lord, that's the case about. Till today, still, as on date, the judgment of in Agras prevail. If they want to really bring up, they have to bring up by an act which is consonance with the Central Act. Till today, the judgment holds good. And my lord, this is about one aspect of buffalo fight. Bulbuli fight also we have challenged that. And our whole case, Bulbuli fight, was that, my lord, under the Wildlife Protection Act, my lord, there are 2 writ petitions which has been filed. Under Wildlife Protection Act, my lord, if your lordship looks into it, section 9. Section 9 is hunting. What is hunting? Kindly see, my lord. Is absolutely, it is, they cannot, my lord. Kindly see, my lord, the Wildlife Protection Act. Then I will take to buffalo, my lord. 2023, latest. Universal. Yes, same book. No? Same.
This is wildlife protection.
Wildlife. Just second writ petition about Bulbuli. I'll show directly that particular provision, my lord.
Section
9. Kindly see section 9. See section 9. Prohibition of hunting. No person shall hunt any wild animal specified in Schedule 1 and 2 except as provided under section 11 and 12. 11, 12 is hunting of wild to permit certain cases. But if you see, my lord, Schedule 1 and 2. Now, please look into the Schedule 1 and 2. Schedule 2. In code book, I think it's page 19. 98. Sorry, 98. It is Schedule 2, no? Schedule 2. Kindly see Schedule 2, my lord. Part B, 98, nahi, quoted here, 98. Yeah, I think it's 98. If it's 98, my lord.
Yes.
If you see, my lord, Schedule 2 at page 103, sorry, it's my 98. Kindly Schedule 2, because if you see 9, it is prohibition, wildlife specified in Schedule 1 and 2. 2, kindly look into it. A is mammals. My lord, you please turn to next page. Part B is animals. Lordship got it, birds. Part B is birds. Now, please go on further. Serial number 63. 63. Red vented bulbul. So now, this is on the schedule. So there is a prohibition that you cannot hunt. What is the meaning of hunting? Please look into the definition of 216. Kindly see definition of 216. Definition of 216, 216, subclause 16. 216. Definition. Hunting, which is grammatical variation and cognate expression, includes A, my lord, this will not fall. B, kindly see, capturing, coursing, snapping, trapping, driving, or betting any wild or captive animal. Every attempt to do is a capturing. So once you are hunting for the purpose of capturing, and which is a part of the schedule, my lord, there is no question that this fight can be held, my lord, because there is a prohibition in it.
What is coursing?
Well, I'm sorry.
What is
Coursing
coursing?
here. Coursing. Please see. What is coursing?
Okay, then.
Our will be B, capturing. Got it, my lord? So there is a restriction under the wildlife.
Hunting technique.
Hunting
technique.
Hunting technique, my lord. That's hunting technique. Now, my lord, will kindly look into the case, the second case. Yes. Will you? 468. My lord, will kindly look into
Where
the
is buffalo here? Buffalo?
Yes, I just Buffalo is 466. Buffalo, what we are saying, my lord,
466?
466 is a writ petition.
No.
There are two writ petitions.
Is
There-
it?
there are two-
Is it a part of the schedule under the wildlife?
No. Wildlife is under the Act. Why I'm saying, kindly now take into the Wildlife Protection Act 1972. How? I'll just show the Act first. Wildlife? No, wildlife. No, prevention of cruelty. Kindly take this Act, my lord. Prevention of Cruelty to Animal Act 1960. This is about, my lord, bulbul. Bulbul is there, no? This is buffalo is under Prevention of Cruelty to Animal Act 1960. Lordship got it? Please look into 11, section 11. 11, treating animals cruelty. Lordship got it? A, 1, if any person beats, kicks, overrides, overdrives, overloads, tortures, or otherwise treats animal so as to subject it to unnecessary pain or suffering, or causes or being the owner permits any animal to be so treated, or B, employs in any work or labor or for any purpose any animal which by reason of his age or any diesel infirmity own sore or other cause is unfit, or so employed, or being the owner permits any such unfit animal to be employed. Or now, if your lordships look into the 11M, 11M, our whole case will be 11M 2 and N. Kindly see 11 2.
Yeah.
Solely M is solely with view to providing entertainment to Roman 2 incites any animal to find or bet any other animal, or Number N, organizes, keeps, uses, acts in the management of any place for animal fighting or for the purpose of betting any animal or permits or offers any place to be so use or receive money for the admission of any other person to any place kept or used for any such purpose or purposes. So here in the state, if there is a fight or buffalo fight, it is in between two animals. So there is a fight with inside, and it is a fight between two animals, and which, my lord, there is always my injury. In the investigation also, there is a report which we investigate. Now the issue here, my lord will kindly looks into one provision of the Act, Section 22, my lord. Kindly see Section 22. See Section 22, my lord.
Yeah.
See restriction on exhibition and training of performing animals. No person shall exhibit or train any performing animal unless he registered in accordance with provision of the chapter 2 as a performing animal. Any animal which the central government may by notification in the official gazette specify as an animal which shall not be exhibited or trained as a performing animal. So, my lord, there are two things under 22 days restriction. If you see one, my lord, they can perform unless he is registered. Registration, your lordship will find the procedure under 23. But if you see 22 Roman 2, there is a gazette notification which has been specified certain animal which you cannot exhibit or train, my lord. Am I clear, my lord?
Yes.
Now, if you look into my petition, that is 466, 2024, that's Buffalo, that is the writ petition, right?
Yes.
See kindly 41.
Page
Page
41.
41.
Yes.
See Ministry of
Yes.
Ministry of Environment and Forest notification, 11th of July 2011. In excess of the power conferred by Section 22 of Prevention of Cruelty to Animals Act so and so, and in supersession of notification of the Government of India in the erstwhile Ministry of Social Justice and Empowerment, except as respects things done or omitted to be done before such supersession, central government here specify the following animal shall not be exhibited or trained as performing animal with effect from date of publication of this notification, namely bears, monkey, tigers, panthers, lions. Number 6 is bulls. We say that bulls is a male bovine which includes buffalo, which your lordship will find in the judgment of the Supreme Court. Your lordship will look into it because my lord, 107, kindly look into page 107. For a moment, just connect it, then I will take it. It'll be easier. See 107. What is bulls? What do you mean by bulls? Page 107. This is a judgment of the Supreme Court where they have, my lord, Karnataka, Kambala, Jallikattu, they have explained 107. There are three, section 11, kindly see on right hand side, my lord. If you see three columns, the third column, kindly see, in section 11, lordship got it, of the Principal Act in subsection 3, after clause E, the following shall be inserted, namely, the conduct of Kambala with a view to follow and promote traditional culture and ensure preservation of native breed of buffaloes, so also their safety, security, and well-being. The conduct of bulls raised or bullock cart raised with a view to follow and promote traditional culture, ensure preservation of native breed of cattle, and also their safety, security, and well-being. So these bulls, my lord, is
No, these, the
Now,
refers,
now, my lord,
this refers to some amendments.
yes, now I'll tell you, lordship.
Amendments brought in where?
Yes, 105, kindly see 105 for a moment. Kindly see 105 on the third column down below, 105.
Yes.
See 105 on third column. Now, DD, kindly say DD, my lord.
Hmm?
In 105 third column,
Yes.
D and double D.
Yes.
Kamala means the traditional sports event involving buffaloes, bracket male, race normally held as a part of traditional culture in the state on such days and places as may be notified by the state government. So this is what I am saying. Bulls is a male bovine. It includes buffalo. Because your lordship may ask, in this file there is an amendment. There was an act which is amended. And the Supreme Court Constitutional Bench said there is an amendment which is consonance. They have kept in consonance with the act. So we will not interfere it. But here, our whole case, number of states, my lord. There are some state doesn't have an act. They come up with a cabinet decision to an SOP.
No, first tell us, this judgment of the apex court,
Yes.
so far as bull is concerned,
I mean,
so far as bull is concerned,
yes.
that it includes a buffalo.
Yes.
Where is that finding of the apex court?
Apex court, no. In the third column 105, they are using it. 105. That's what I am saying. They are using it. If you
No,
see
no,
at 104.
It is a reference to some amendments brought about. In
Yes,
the
kindly see
1960 Act.
Karnataka Amendment Act.
Huh?
Kindly see 104. 104.
This is 1960 Act.
1960 Act enacted in personal legislative power contained in entry 17. So and so to the impact of the Amendment Act, main statute will be revealed from the comparative table given below. Now that act, my lord, provision kindly see 2017. Cruelty Amendment Act
So this is
2017.
this is
No, what?
This analogy that you're trying to draw
What?
is what is evident from the Karnataka Act.
Yes. Well, what I am trying to bring back home.
Is it also available under the 1960 Act?
1960 Act. No, that point, buffalo, they always considered buffalo as a part of bull.
No,
That
no.
was never raised.
Who are they?
No, they, Supreme Court, my lord. The apex court.
So therefore,
Yes.
you show us the relevant paras, relevant finding.
Your lordship will not find, I know, your lordship will not find anywhere the buffalo. Your lordship will find the gazette notification which been restricted is bulls. Now the question came up because those particular at page 105.
Now,
Very
whether bull includes a male buffalo,
yes,
or is restricted only to bovine, is something to be interpreted either by the government or by the court on the basis of materials available.
But
so, is there any finding?
My lord, if your lordship looks into the finding of the Supreme Court, because that judgment, first judgment of A. Nagaraj, which we are relying as on date.
That's what we are asking you. Take
Yes.
us to the relevant paragraphs.
Yes. Very good. From where you return? We have not annexed that. My lord, we got in the course when it was deliberated, we really, whatever the concern about your lordship, was a concern about me also, very honestly. Then I told them, my learned friend is of Delhi, I told them, why don't you find out some certified, some ICAR has said, my lord, this is what investigation has made and they have written that, my lord. Kindly look into it, my lord. We have to, of course, my lord.
The appropriate authority would be the veterinary and the animal husband.
Kindly see, my lord. What is this animal?
What is this? What is this document?
This is recognized. My lord, this is recognized by whom? Animal Welfare Board of India. They
That's
recognize.
it. No. They appears to be an NGO, perhaps.
Yes. NGO.
It's an NGO.
NGO.
It's not a government organization.
Animal.
This is a,
It's an NGO. But my lord will kindly see number 2 definition. On its page, lordship got it.
no, we want to get this material from that authority who deals, who has classified it. This is an interpretation by an NGO.
My lord, authority has been referred here at 2. Kindly see
So
definition.
get us this material. Do you have this material with you?
Have you all?
Get us those material.
One
See,
second.
either you show us from an authority of a court to say that this is bull and this is not bull. Right? So far as the Wildlife Act, that particular breed of bird is under Schedule 2.
Yes.
So therefore, it's covered under wildlife.
Right.
But so far as bull is concerned, whether bull would also include a buffalo or not is a matter of interpretation unless there is a clear finding somewhere.
But what we found.
You take us.
No, that's
for-
your lordship. I've understood, my lord.
Hmm.
What's your lordship exactly? I understood. But if your lordship looks into it, but this is not- where is the connection, my lord? See, where is where is the connection? Because what?
What is the function of this board?
Which one, my lord?
Animal Welfare Board.
Yes. What is it? What is it? My lord will kindly see one paragraph 1 first. What they do? One of the two this animal Rahat mines, this particular, which I have given a note. It's from the veterinary I am the chief operating officer of
This is an NGO.
animal welfare organization.
No, see, that's a personal opinion of somebody. We are not discrediting it.
Yes.
What we want to know is
But
that
just
if in the first instance, if you have this material coming from recognized government departments who are doing this work or competent to give a definition or a clarity on this subject, we'd like to have
so
access
that
to
I
those.
very frankly saying, yeah, I understand. I know, but where is that speaking to the authority? An NGO.
You get this authority,
No,
you
my lord,
tell us.
this week we couldn't hold it. Let us be very honest to it.
No, it has to be
No,
there.
what we no 105 we are interpreting. We are saying this is judgment. That was never an issue. But the issue that what the Supreme Court has said in this, my lord, 105 they have stated here. My lord, that also was they said here.
Mr. Counsel, a great deal of respect. See, you are trying to give a proposal. You are trying to propose something, an argument, that this is bull and therefore it is prohibited under this act. Now that particular material, unfortunately, is not available in the statute.
Statute it is not available.
This is bull or
It is bull, it is there, it is not available.
So it calls for an interpretation.
Buffalo has not been defined anywhere in the statute.
It calls for an interpretation.
Yes.
Question is, who is their authority to interpret? Yes, respondents.
Yes, there is a judgment. I will get hold of the judgment
Right.
of 1958, where bull has been animal means defined in a judgment.
Okay.
Bull means an uncastrated male above the 3 years belonging to species of bovine cattle, and bullock means in so and so 3 years so and so. That is buffalo. We'll get hold of judgment law to 9. Yeah, that's where is the board.
Who's for the Animal Welfare Board?
No, suppose, no, they are performer. My lord,
They are the authority to tell us.
No, for a moment, I'm just putting in this way, my lord. Suppose for a moment, let us say the notification, which there is a state government on a restriction on this notification at page 41. Now, for the time being, your lordship wanted to know that bull is also somewhere you have to find out whether you can find out the statute where a bull has been defined as buffalo. If I've understood correctly, my lord. Or is there any judgment of a court where it has interpreted this, what do you mean by bull, whether it includes a buffalo also? Now for a moment, if for a moment 41 is been taken side and we take into, keep apart, my lord, we take into the Prevention of Cruelty of Animal Act for a moment.
Yes.
Even then, my lord, Section 11, there is a bar, there is a provision. There is a restriction. Kindly see. Of Section 11 of the Act, Prevention of Cruelty, Animal Act 1960.
Yes.
For a moment, my lord, let us keep aside that notification. Let us see now 11. My lord, the bulbuli is clear, my lord. There is unless
I'm
they
not,
have, no.
I'm
clear.
not saying it is clear. We are saying that yes, there is an act.
Yes.
It contains a schedule. The schedule contains, according to you, includes that particular breed of bird, which is a wildlife. And
Yes.
therefore, whether it is permissible, can be excluded or not, is an area that, if required, we can go into. But
Yes.
prima facie, it is a part of the schedule.
Right.
So far as this bull is concerned, it is not clear from the provisions of the Act.
No, let us for a moment, let us keep aside that notification. We research on that. My lord, if you go by 11, treating animals cruelty. Now, my lord, your lordship, there are three particular spots, Karnataka, then Maharashtra, and Tamil Nadu. That is not a fight between two animals. It is a race. In Karnataka, in Maharashtra, there is a race, bullock cart race. So there is no chance of getting injury because there is no fight to one to one. There is no 1-to-1. Now, in Karnataka also, it's the same. It's a race. It's a race. What we are in Karnataka, then also Maharashtra, and also Jallikattu. It's a bull, my lord. It's a bull fight. It's a bull. Oh, there is no question of any injury. But here, if you see in our state, it's a fight, buffalo fight. It is between two animals, which there is an injury. And how they tame this, that also, which my argument is, if your lordship looks into section 11 and M, N.
Yeah.
So one is 11A, B, and read with M2. Inside any animal, so any animal to fight or bait any other animal. So here any animal is given, irrespective of that notification, any animal. So what our submission before this court is that if you also for a moment leave apart that notification, even my lord, this fight cannot be held because of an animal which is fighting, and we have given some photographs how it has been done, how it is injured. Kindly see where is your the photographs? Kindly see, my lord. 166. Kindly see, my lord. Kindly see 166, my lord. See at 166.
Yes.
166 and page C 169. This is what. So kindly see the person is beating this bull and these two bulls fighting each other. Don't you got it, my lord? All 170, 171. Now this 172, they are ready. These two bulls. Force them to fight. Now see that 172 photographs pushing a buffalo towards another buffalo to force the animal to fight. Now kindly 173. These are blood zone, my lord. That page 173. See photograph 9, my lord. Buffalo bleeding from the ear and neck during a fight.
Yes.
See what 174. 174.
Yes, yes, yes.
See all, my lord. Down below and also on the top. Bleeding
What
from
are
the
the
forehead.
what are the consequences of violation of section 11?
Yes. Offenses. Under section 126. This is 26, section 26 on the PC. And this is section 26. Offenses.
Mm.
What you got it, man?
Yes.
Offense if any not being registered on a chapter, exhibit or train, any performing animals, or being registered on the exhibit or now there are two things which I said, my lord. My lord, by our notification, there is a restriction. Now that we keep aside the restriction, now if we say any animal, then your lordship has to see 22, 23. 23 first. See 23. See
No.
22, 1.
No, let us come one by one.
No, let us, sir.
Section 11 defines what is cruelty.
Yes.
Is there any provision which prescribes penalty for inflicting cruelty or in violation of section 11?
Yes.
Or uh, it falls in any of the definitions given under section?
It is two section. One is 26 the offenses and C 31.
26. 26 has no reference to section 11. Part
31 has reference. 31.
31.
31 of the 31. Don't you got it? Punishable and so and so one
But
clause and
no, this is about cognizability of offenses.
yes.
Where is the offense described? Where is it described that it will be an offense?
At the end of 11, 1. 11, 1.
Shall be punishable.
Yes. Provided so and so owner shall be deemed, provided where the owner is convicted, cruelty so and so. This is, he shall be punishable. My lord,
Punishable with only fine.
M2.
Only fine.
Yes. M2. Kindly see M2. He shall be punished in case of first of it so and so. Offense committed 3 years or so and so shall not be so and so. One owner shall be deemed to commit an offense he has failed. Convicted of primary cruelty by reason only having failed to exercise so and so. Nothing in section shall so and so.
So there is a provision for punishment.
Yes. No action has been taken. That's the whole problem. No action is taken. We lost so many FIRs. They are not taking any action. This is going on. Our whole case is about section 22. Section 22. But your lordship is asking that where is that? We want to know that bull also fall within definition of buffalo. If that, my lord, I can satisfy, then straight away, my lord, then of course it is a,
No, if you look into the definition
yes,
of animals, this is 2A.
yes,
2A is animal.
yes,
So it means any living creature other than a human being.
yes,
So bull or otherwise, buffalo or cow,
Yes,
whatever it is an animal.
yes,
Definitely not a human being.
yes,
So it has to be an animal.
yes,
Now, if this is an animal, there is a specific provision under this Act of 60 for what is to be defined as giving cruel treatment,
yes,
which is 11.
yes,
Now, on the 11, you have pointed out clause M and N.
yes,
So, M2 is inciting any animal to fight.
yes,
N is organizes, keeps, uses, so and so for so and so. So, these, if anyone is found guilty for the
yes,
second offense,
Yeah.
there is a punishment of imposition of fine as well as with imprisonment.
Yeah.
So,
That is there, one part is there. That is not, one part is there. But whether they can really organize, that's the whole issue.
the Act prohibits.
The Act prohibits, that's what I'm saying. If the Act prohibits, then the SOP which has been issued by them,
Where is that SOP?
that SOP your lordship will find at 42.
42.
Yeah,
Yes.
42. When the following SOP guideline is framed to
Is there,
ensure.
before we go to the SOP, is
Yes.
there any exception provided under the particular Act?
Not for anything, no exception. Not for Assam, madam. There is no exception. All power has been is under this Act, Central Act. Mano, if you see 38, section 38 of the Prevention of Cruelty Act, section 38.
Yes.
I don't know.
38.
38,
For
38.
making rules.
Yes, power to make rules.
Hmm.
The central government by notification official gazette subject to condition of previous publication may rule to carry out the purpose of the Act.
No, there are exceptions in 27 and 28, under which, of course, these fights are not included.
Yes. It is by virtue of this Act, the power is given to the central to make the rules. Twenty-eight, my lord will kindly see, 28, section 28. Lordship got it, 28,
28.
section 28.
Yes.
Saving as respect manner of killing prescribed by religion, section 28. Nothing contains the act shall render it any offense to kill any animal, any
This
manner.
is not an issue here.
Yes, not an issue. That's why I am showing that this is what in Kamakha, my lord. That's not the issue. That particular, that you, section 28 that empower.
Now, what does the rule say?
Yes. Now, my lord, one thing may I show can I show that once again 22, once again, man. 22,
22.
section 22, 1.
Now, before that, tell us one thing. There was a description about a performing animal. What is that
Yes.
performing animal?
Performing animals, your lordship will find in the rules, performing animal registration rule 2001.
No,
Kindly look into
under
it.
the act. Under the act.
No, this is defined under the rules, H. Kindly see H of definition 2H. What is performing animals?
2H.
2H, performing animal registration rules 2001.
No. Under the act, is there
Yes.
any description?
Yes,
Under the act.
I am looking at. Okay.
Not here.
No, it is only your lordship will find in the rules only. 2001.
Performing animals registration rules.
Yes, great. It's H.
H.
Performing animals mean the animal which is used it or for the purpose of any entertainment, including a film or unique event to his public eye admitted. Now these are registration rules, my lord. That's why I want to show 22, 22.1
Of this
of
act.
the Act. 22.1.
Yes.
22.1. Restriction on exhibition, training, or performing animals.
Right.
No person shall exhibit or train any performing unless he is registered in accordance with the provision of the chapter.
Yes. Yes.
See, now if it is, my lord, he has to be registered if you want to perform. See the procedure at 23. 23.
Yes.
Procedure for registration. Section 23.
Yes.
Every person deserves exhibiting or training any performance shall, on making an application in the prescribed form to the prescribed authority and on payment of prescribed fee by registered under this, unless a person who by reason of an order made by the court under this chapter is not entitled to be so registered. Now these are procedure has been laid down, how it has to be registered. Now this rules is only related to performing animals which is registration, registered 2001. This rule. So there are two things, restriction under section 22. You can perform unless it has to be registered and a procedure has been laid down. And the rules is the performing animal registration rules 2001. How it has to be, what application, in what manner you have to file it, or it is under the rule.
But even if you are registered
Yes.
as a performing registration as performing animal, but it will not be an exception under section 11.
Yes. Very-
Yes.
Now, what I found in this not in context with that rule, somewhere your lordship will find in this act itself, the prevention of cruelty of animal transport of animals on foot, rule 2001. Kindly look into it, man. Just this is I found, that's why I wanted to show.
Yes.
See this act and kindly see definition of animal. Like the animal means livestock into the following animal, namely cattle, including cow, bulls, and bullocks, buffalo bulls, and bullocks, cow, buffaloes, mithun, yaks, and calves. So here where it defined here, cattle including cow, bulls, and bullocks, buffalo bulls. Lordship got it?
So this is for a definition of animals.
Yes,
So the definition of the act itself is very clear.
very, very clear, very clear.
Anything which is not human.
Yes. Just I am bringing it from the, because as we will not find in the act, so I try to bring this. But your lordship is right that otherwise there is restriction under 11. So what my submission today, my lord, let this particular SOP be stayed. This SOP should be stayed because Bulbuli your lordship has seen, and this SOP should be stayed and let them file a detailed affidavit that can be heard this matter, my lord.
My lord, the SOP your lordship will find is dated, my lord, 27th of December 2023, my lord. It has been, my lord, given the background of buffalo fights, my lord. The lordship,
Have you filed a counter affidavit?
my lord, we have filed an affidavit, not as para-wise, but we have given that because after issuance of, my lord, this SOP, my lord, no.
Prima facie, it appears to be violation of this Act of 60. How do you
My
defend your?
lord, here, my lord, because in the SOP, my lord, all, my lord, my lord, any injury or, my lord, any cruelty to against the animals have been taken care of, my lord, with given the, my lord, guideline
How
standard.
can you take care of cruelty to animals if you allow the animal, if you put these animals to fight each other?
My lord, here I would, my lord, respectfully, my lord, take your lordship to page 143, wherein, my lord, that Jallikattu judgments, my lord, the Honorable Supreme Court has taken care of to the extent that if it is, my lord, for, my lord, years together and it is the, my lord, if it is religious and, my lord, cultural and social analysis, then, my lord, it cannot be, my lord, that it will not, my lord, be said, that cannot be said that it is,
See, with first thing you have to answer the
My lord.
mandate of the Act.
my lord.
This Act of 1960 is applicable in Assam.
Act is, my lord, you can deny the act, my lord. Act
Then,
is there, my lord.
so if the Act is there, then it doesn't permit you to go for state amendments. How do you permit something to
To continue on,
continue,
my
which
lord.
is prima facie violative of the definition?
Yes, my lord, lordship, in case of that one, my lord, I want to take your lordship to, my lord, page 43, 143, the relevant portion, wherein, my lord, Honorable Supreme Court has observed, constitutional bench of the Honorable Supreme Court has observed that if it is, my lord, religious, my lord, because here, the buffalo fights have been, my lord, for last 400 years, my lord, it's been organizing by the, my lord,
Is it no, these history, no one is questioning it.
lordship, lordship.
If you think that this is a practice, this is a custom,
My lord.
make a law. The law
Lordship.
which is in
Yes,
force
lordship, correct, my lord.
clearly prevents it.
Lordship,
No one is stopping the state to make a law.
lordship.
But unless you do it, merely
Lord.
because you have a long history, you can't say that it is permitted. You take us to the appropriate paragraphs of the judgment to tell us that it is permitted.
And because the Jallikattu judgment is obviously in case of Malad Jallikattu, Tamil Nadu Amendment Act, Malad. So here only to that extent, Malad, that is 143. This
Yes.
paragraph 40.
Yes.
Roman 2, Malad. The Jallikattu is a type of bovine sports, and we are satisfied on the basis of materials disclosed before us that it is ongoing. It is going on in the state of Tamil Nadu for at least last few centuries. This event essentially involves a bull which is set free in an arena, and human participants are meant to grab the hump to score in the game. But whether this has become integral part of the Tamil culture or not requires religious, cultural, and social analysis in greater details, which, in our opinion, is an exercise that cannot be undertaken by the judiciary. The question as to whether the Tamil Nadu Amendment Act is to preserve the cultural heritage of the particular state is a debatable issue which has to be concluded in the House of the People. This ought not to be a part of judicial inquiry, and particularly having regard to the activity in question and the materials in the form of tax cited before us by both the petitioners and the respondents. This question cannot be conclusively determined in the writ proceedings since legislative exercise has already been undertaken. In this case, since Malad Act is there, Malad. Jallikattu has been found to be part of the cultural heritage of Tamil Nadu. We would not disrupt this view of the legislature. We do not accept the view reflected in the case of A. Nagaraja that performance of Jallikattu is not a part of the cultural heritage of the people of the state of Tamil Nadu. We do not think there was sufficient material before the court for coming into the conclusion. In the preamble to the Amendment Act, Jallikattu has been described to be the part of cultural and tradition of Tamil Nadu. In the case of A. Nagaraja Supra, the division bench found the cultural approach unsubstantiated and referring to the manner in which the bulls are inflicted pain and suffering. In division bench concluded that such activities offended section 3 and 11(1)(a) and M of the 1960 Act. Even if we proceed on the basis that the legislature is best suited branch of the state to determine if particular animal sports are part of cultural tradition of a region or community or not, if such cultural events or tradition offends the law, the panel consequence would follow. Such activities cannot be justified on the ground of being part of cultural tradition of the state. In Nagaraja, the sports were held to attract the restriction of section 3 and 11(1)(a) and M of the 1960 Act because of the manner it was practiced. The Amendment Act read with the rules seek to substantially minimize the pain and suffering and continue with the traditional sport. The amendment having received presidential assent, we do not think there is any flaw in the state action. Jallikattu as bovine sports have to be isolated from the manner in which they were earlier practiced, and organizing the sports itself would be permissible in terms of the Tamil Nadu rules. So, my lord, here, after all, the court has, the Honorable Supreme Court has, my lord, taken care of that regarding their, my lord, cultural side, my lord. Uh, 42
But
however,
there was the issue was whether Amendment Act is in conflict.
there's act is there, my lord, but here we admittedly we do not have the act, my lord. But SOP has taken care of, my lord, and regarding, my lord, not taken action against, my lord, violation, my lord. My humble submission is there is no violation after, my lord. But the whoever violates, my lord, FIR was lost, and we have taken action, and CS has already been submitted. And, my lord, we have taken all any FIR, my lord, lost in violation of this act.
Where is your SOP? Where is your SOP?
Page 40, my lord.
52.
Please read your SOP.
My lord, the following SOP guideline is framed to ensure that buffalo and other traditional birds fight are allowed to be organized in all places where it has been traditionally organized with specific provisions for regulation by the district administrations to ensure that cruelty to animals is not allowed to be inflicted. Background of buffalo fight. The event of buffalo fight Mojus is an integral part of the culture and tradition of Morrigaon and Nagaon district etc. in Assam for centuries. The event was organized formally during Ahom's rule, especially in Ranghar. It is observed mainly during Magh Bihu festival. The political, economic relationship between Tiwa Chief Gobha Raja of then undivided Nagaon district and Ahom Borfukon and the tradition of the Jonbil festival bridged the gap between the two historical kingdom of Assam, which smoothened the road through which the tradition of Mojus would flow to undivided Nagaon district, Nagaon and Morrigaon district from Ranghar. Historians believe that Mojus was practiced in undivided Nagaon district in a different form, unorganized and unprofessional before the 17th century. The relationship resulted in the intermixing of cultures and traditions between the people of Tiwa and Ahom kingdoms, which culminated in the formal introduction of Mojus in the undivided Nagaon district. The Honorable Guwahati High Court by order dated 10/10/2023 passed in writ petition number 73 of 2016 directed the state government of Assam through the Chief Secretary to look into the aspect of the long-standing tradition of buffalo fights being performed in the state of Assam during the festival of Magh Bihu, which is a part of tradition, as well as the aspect of the well-being of the animal being put to jeopardy because of any provocative acts being inflicted by the organizers, and thereupon to take a conscious decision on the matter. The Honorable Cabinet
What is this writ petition 73? That has been disposed of.
disposed of, madam.
That your lordship will find where is the
73 of 16 is part of record, my lord. Your lordship will find at page 148, my lord. Writ petition, my lord.
All right, you continue reading.
The Honorable Cabinet on 8/12/2023 decided that buffalo and other traditional birds fight can be allowed to be organized in all places where it has been done traditionally over the years, and directed Home and Political Departments to come up with a comprehensive SOP to ensure that buffalo fights are allowed to be organized in all places where it has been done traditionally, with specific provisions for regulation by the district administrations to ensure that cruelty to animals are not allowed to be inflicted. Accordingly, the following SOP is prescribed for buffalo fight and bulbuli fights, birds fight. Background of bulbuli birds fight. Although there is no documented history about when bulbuli fight started, old timers says it was started by the great Ahom king Sorgodev Pramata Singha during his rule between 1744 and 1751. People believe that the king saw two bulbul birds fighting while descending the stairs of the temple. Thousands of people from across Assam converged on the town of Hajo in Lower Assam's Kamrup district to witness the famous bulbul fight that takes place during Bhogali Bihu. A birds fight in the Sri Sri Hagriba Mahadev Mandir premises and kept the ban order dated 13/1/2015 in abeyance until further orders. Then Mala standard SOP guidelines for Mojus buffalo fight. District administration should ensure that all rules and regulations along with the SOP is strictly followed. Concerned district commissioner will issue permission to the organizing committee on the basis of the application from the organizers. Mojus shall be allowed only in those places where there is a history of organizing such events at least 25 years. Mojus may be allowed at a specific time for a year to be completed within 10 days succeeding Magh Bihu, that is 15 to 25th of January. No Mojus shall be allowed any time of the year except the period stated. The organizing committee shall ensure that Mojus is scheduled between 7 a.m. and 4 p.m. Veterinary department will depute a veterinary team at the spot where Mojus is organized to respond to any medical emergency to buffaloes. Where Mojus is organized in large scale, veterinary ambulance will be made available at the spot along with veterinary team. Organizers of mojos must make arrangements of sufficient food, water, sunset for buffaloes at the venue as may be necessary. The complete mojos program showing date, time, and place shall be videographed. The organizing committee should ensure the proper videography of the complete event. Strong barricading of the fighting arena shall be done by the organizing committee. All human inflicted injuries shall be prohibited at any cost.
All right, all right. Now,
Only-
let us take us to the judgment of the court earlier.
My lordship will find page 148. My. It starts from 149. My.
Yes.
Third section, Church, my lord. By this petition, the petitioners essayed an order dated 13/1/2015 of the officer in charge of Dharamtul Police Station, which provides that pursuant to the directions of the Honorable Supreme Court and Supreme Court, the President Secretary of Uttijya Mandita Athaguri Ansolik Mojus Committee was asked to refrain from conducting the buffalo fight. Mr. Talukdar Senior for the respondent relies upon the pronouncement of Honorable Supreme Court Animal Welfare Board India in Nagaraja and others reported 13, wherein in paragraph 35, upon interpreting section 3 of the Prevention of Cruelty Act 1960, it was observed that well-being of the animals means the state of being comfortable, healthy, or happy, and forcing the bull and keeping the same in the waiting area for a number of hours and subjecting it to scorching sun is not for the well-being of the animal, and forcing and pulling bulls by nose ropes into the narrow closed enclosures and subjecting it to all forms of torture, fear, pain, and suffering by forcing it to go to the arena and also overpowering it at the arena by the bull tamers are also not for the well-being of the animal. In paragraph 44, it was observed that the bulls therefore cannot be performing animals and automatically not designed out that but are forced to perform by inflicting pain and suffering in total violation of the section 3 and 11(1) of the Prevention of Cruelty to Animals Act 1950. When the relies upon the aforesaid two observations and conclusion of the Honorable Supreme Court to justify the improved communication by which the petitioners were restrained from indulging in a buffalo fight on the occasion of March Bihu. B. Chaudhary, Learned Counsel, on the other hand, submits that buffalo fight is a tradition which existed in the state of Assam since long and is particularly performed as a part of the festival of Magh Bihu. In response to the same, the state authorities has produced an opinion rendered by wildlife experts, namely Sri Vibhav Kumar Talukdar, who is an associate with the NGO Aranya, which is intricately connected with the protection of the protection and welfare of the wildlife. In the opinion, a view is expressed that human triggered buffalo bull fight among domestic buffaloes are totally against the ingrained natural attributes of the buffaloes, and the human induced buffalo fights are mainly organized for the amusement of humans. But the opinion also reflects that buffalo fighting in some aspect of a part of India is recognized as a tradition, and there are various superstitions associated with buffalo fighting in India. But what is noticeable is that the opinion also states that in such human-induced buffalo fights for entertainment, the buffaloes are brought into the arena by their respective owner and are subjected to commotions. Loud instruments like gongs are played in order to agitate the buffaloes, and sometimes they are kept tied up and hungry for days to make them aggressive. And also on some many occasions, the buffaloes are forcibly fed local intoxicants for creating anxiety, aggression, and restlessness in the buffaloes. And further, often in such human-induced fights among buffalo bulls, there are fatalities to the buffalo and buffaloes. A reading of the above.
So your SOP is pursuant to this judgment.
Yes, my lord. Later on, my lord, court has lordship. There are another about 3 pages left, my lord, because then court has observed, my lord. May I done, my lord? Continue or my lord? Because last part, lordship will see, my lord. Done, my lord.
Seven
In the
is important.
circumstances, my lord.
7, 8 is important.
Page 53, my lord, last part.
No, but at the end, it is the direction of the court to the
My lord.
state to examine the matter, take a conscious decision.
Yes.
They have taken a conscious
They
decision.
have taken a conscious decision, they remain the same.
No, not
That's why SO.
No, no,
after
no.
that.
We're not on that. We
Yeah.
are on this concept, on this, that this issue of whether it should be held or not held, examinations, matter was examined and the judgment of the apex court, two judgments of the apex court were placed. And the court directed the state to take a call.
That's why state has taken a cabinet decision.
No, it is
But
after
one
that.
second, but they have taken a decision. In pursuance to that, this SOP has been issued.
Right.
Now, this SOP as on today, what improvement they have made? Today also there is a violation.
No, no. The fact that it was in violation
Yes,
was a stand taken by the state before the court.
yes, right,
No, result
It's
was
reflected here
yes,
in para 3
yes.
that it is a violation of Prevention of Cruelties and Act
Eh,
1960.
That is what, that if that is the stand taken by the state and in violation of judgment, then this SOP which has been issued, a cabinet decision, they ought not to have a.
No, no. What I see, the stand of the state was that it was in violation of the section relevant section.
Yes, 11, yes,
Cruelty of
yes,
before issuing SOP.
Yes.
rather relying on the judgment of Nagaraj.
yes.
Right. So ultimately, the court directed the matter to be decided on the basis of you read para 15 in
My
fact.
lord, para 15, yes, at page 53. In the circumstances, the respondents in the state of Assam through the Chief Secretary of Government of Assam to look into the aspect of the long-standing tradition of buffalo fights being performed in the state of Assam during the festival of Magh Bihu, which is a part of tradition, as well as the aspect of the well-being of the animals being put to jeopardy because of any provocative acts being inflicted by the organizers, and thereupon to take a conscious decision on the matter. Any resultant decision that may be taken be informed to the court for the purpose of Chief Secretary, for the purpose the Chief
This
Secretary
direction
to account.
was given to the chief secretary to look into this aspect of long-standing tradition of bullfights being performed in the state of Assam.
Yes.
This is the direction of the court.
Yes.
I know, but that has to be kept in consonance with the act. The direction they
So
cannot.
if you are
being a
aggrieved,
culture.
if you are aggrieved by this finding,
No,
you know what.
No, in person to finding this 42. In person to finding page 42. Kindly look into it.
And my lord,
Well, one second.
My-
It's asking something, you are giving a reply.
No.
See page 42.
Yes.
Your lordship is saying that if you agree this finding,
Ah.
you should have moved. If you are aggrieved by it, there is no, my lord, with great respect, my lord. See page 42.
Yes.
Kindly see the second paragraph. The Honorable Guwahati High Court right order passed in so and so directed the state government of Assam to look into the aspect long-standing tradition of so and so being performed in the state of Assam during festival of Magh Bihu, which is a part of tradition as an aspect of the well-being of the animals being put to jeopardy because of any provocative acts being inflicted by the organizer, and thereafter to take a conscious decision on the matter. The Honorable Cabinet decided that buffalo and other traditional birds fight can be allowed to be organized in all places where it has been done traditionally over the years, and directed Home and Political Department to come with a comprehensive SOP to ensure that buffalo fights are allowed to be organized all places where it has been done traditionally, with specific provision for regulation by district administration to ensure that cruelty of animals are not allowed to be inflicted. So in pursuance to this, they have taken a decision. SOP has been issued. We are challenging the SOP on the ground.
See, the matter was before the court.
Yes.
Court did not decline to examine this issue. The judgment of the court will have to be understood that notwithstanding the provisions of 1960 Act, there was a direction issued to the state to look into
They
this
have
aspect
looked into, and
from the standpoint of tradition.
the court never said that you look into and do a particular act which is in total violation. The court didn't say.
No. If the Act prohibits,
Yes,
in the first instance, where is the occasion for a court to direct, to look into it?
no, look
The Act,
in,
there is a provision,
today.
there is a bar.
No, today I am saying if this 42, your lordship, I am challenging this 42.
You are challenging
There is
it,
no
but
bar
this
to
is
challenging
pursuant.
it.
This is in pursuance to a judicial
Maybe,
order.
my lord, there may be in pursuance with, but there are a lot of judgments lot of judgment passed by the court by parliaments, my lord, that judgment.
See, you give us the understanding in
No, no, I have-
respect
my
of
lord,
para 15, the
My
import
lord,
of
I
para
have read
15.
this judgment, my lord,
Yes.
with great respect.
Yes.
My understanding before your lordship of that judgment did not culminate into a final decision to be taken by a state,
So
which is totally in violation of
what
the
has happened to this writ petition?
which written.
This
This
writ
is
petition?
disposed of.
No, the
Yes.
order says list on so and so date.
No, kindly see, there is another order which has been passed. Kindly see,
157.
that is in another case, my lord. I am saying that is that another case. Where is that case?
This is 157.
Yes. Kindly see 466.
No, what is 157? This passed in the same order, same judgment.
No, I'm sorry.
155, 156.
Yes. At page 161.
Yeah.
Yes.
Court has taken note of the cabinet decision.
Yes.
Then
Now, in the person to cabinet decision, they have issued this SOP.
what is the one?
I cannot challenge the SOP if I am not agreed.
No, your challenge to the SOP
Yes.
it has to be explained from the standpoint of the judicial orders passed by the court.
That's I'm saying. There is no restriction that I cannot stand. I
No,
cannot
there
challenge.
is no restriction.
Then
But the question is, there is already a finding by the court that it's for the state to look into it and pass appropriate orders.
that's what cases. The state has done it.
No, state has done it.
Yes.
But does it not imply that the court is conscious that notwithstanding the restrictions under 1960, state is it's within the power of the state to pass appropriate orders?
I'm sorry, Manu. That was not decided on the merit of the case. Somebody has filed a petition.
We
Now
don't
we are
know, but
bringing.
this is an order of the court.
But order of the court in person.
The reference to 1960 Act was done. Judgments of the Supreme Court was done. The coordinate bench did not hold that notwithstanding the SOP it's barred under prevention of.
No SOP, but SOP. I am telling my lord, SOP. This SOP which they have issued, my lord, that is contrary to the prevention of. How can they issue this SOP, my lord? SOP they could have taken.
Whoever was before the court ought to have urged it that notwithstanding this is a violation of the 1960.
But even, my lord, that High Court order, in persons to that order only notification has been issued. We are challenging this notification, my lord.
Your challenge is okay, but that is
then
in pursuance to then order passed by the court.
My lord, any order passed by that doesn't attain finality. It is only that they have taken a decision. This decision, I am challenging the decision taken by them by way of a SOP.
Which decision you should have challenged by bringing it before the court at the relevant
No, I'm
point in
sorry,
time.
my lord. That's my view, my lord. That's my view of that notification which they have issued.
You can't allow a court order to be passed directing the respondents to take a decision.
My lord, where is the merit of the case has been discussed on the Bulbuli fight also? Where is that, my lord? Now
we are
looked into it.
We are dealing with the
Buffalo. Now, my lord, kindly see what the Supreme Court had said. So where traditional culture is concerned, my lord. Kindly see at page 78, kindly 78, 78 culture and tradition. Of that constitutional bench, they have an act which they have amended. Kindly say 78.
There is a judicial order, Mr. Das. Why don't you understand that?
I have understood, my lord.
Then
this is my limited
we
knowledge.
Are not supposed to give, we are not supposed to give you
my limited knowledge.
Just any legal advice.
My limited knowledge is, my lord, what I have understood, my lord.
Yes.
That judicial order which has been passed, it has been left to the hands of the state. That is not finality that you can hold the fight.
How can something which is prohibited under the Act be left to the hands of the state by a judicial order?
I'm sorry, my lord.
How can something which is prima facie prohibited under the Act be left to the hands of the state by the court?
No, they could have. What the court said? Court did not say that you all. Court said you take a decision. According to the decision has been taken by.
Take a decision when there is a clear bar under the statute.
I know, my lord. That
And
is why
that-
we are. That is why we are before this.
So
on-
that we are
No, my
unable
lord.
to do anything
Why?
in view of
My
this
lord,
order.
I think, my lord, we are here because there is a your lordship is there is a bar under this statute. That's why we have come up before this court, my lord.
You have come up, but this, you have come up challenging the SOP,
That's why I'm saying.
which is
That's
just
right.
equal to a judicial order.
No, that I understand, my lord. But there is a bar, my lord. Can your lordship not look into the because there is a separate
No,
cause.
because the finding,
There is
that finding of the courted bench is binding on me.
my lord, there is a cause of action.
Unless you heard that
No,
these issues were not there, it needs to
that
be
issues
resolved
were,
or referred.
of course, my lord, on the pleadings I will show that issues were not there. These were never discussed. Kindly say culture and tradition. I'll sorry trouble your lordship, page 78. Kindly say 78. They are saying about culture and tradition, how the apex court has dealt. Kindly see 42. Culture and tradition. The statement of object and reason of so and so refers to ancient culture and tradition and does not state that it has any religious significance. But your lordship has seen 28. That is a bar. There is no bar. Even the ancient culture and tradition do not support the conduct of Jallikattu or bullock cart race in the form in which they are being conducted at present. Welfare and well-being of the bull is Tamil Nadu culture and tradition. They do not approve of infliction of any pain or suffering on the bulls. On the other hand, Tamil Nadu traditional culture are to worship the bulls, and bull is always considered as a vehicle of Lord Shiva. Yaru so and so in Tamil Nadu tradition is to embrace bull and not overpowering the bull to show humans bravery. Jallikattu means silver or gold coin tied to the bull's horn, and in olden days, those who gets at the money to the bull's horn would marry the daughter of so and so. Jallikattu bullock cart race practice now has never been the tradition or culture of Tamil Nadu. Now, para 42, 43. PCA Act, a welfare legislation, in our view, overshadows or over the so-called
No,
tradition
but
and culture.
this has been turned down by the subsequent judgment. This view.
Now, turned down by the subsequent.
This has been watered down, this
Then
view.
why? Because there was an act, there is an amendment to the act. That's why the court said, my lord, they have already that lacuna has been filled up by them.
Whatever it may be, but
Yes.
this view has to be read with the subsequent view of the apex court.
No, that's true. Because that is only in connection with the three acts, my lord, three that particular states.
That's what we are
The three
saying, that
states.
this SOP has come into existence because of a direction given by the court.
But what I understand, the direction doesn't mean the court has given a direction that go ahead and do
No,
whatever
but
you want.
does it mean that in the face of prima facie restrictions under a central statute, the court can give a direction to frame an SOP? When prima facie it appears that there is a restriction. There's a prima facie bar. It doesn't call for an interpretation.
So that is why I'm saying, my lord, why am I before this honorable court? Because there is a separate cause of action.
Then you need to think about this order
No,
itself.
that is separate cause of action, my lord.
How is it a separate cause of action?
Why, my lord? In pursuant to they have taken a decision. But why we are not a part of that?
That decision has been left to the state to be taken pursuant to a judicial order passed.
They have taken a decision by issuing an SOP.
Where there is a specific bar under a statute, can a decision be left to the state to take?
No, they cannot. That's why your lordship will stay this. That's why your lordship will stay this. If there is a bar, how is the SOP, even on the face of it, if there is a violation, if there is a bar, so they cannot use it, my lord, as a traditional culture. This is violation of these two acts.
If you want, we can refer it to a larger bench. But you have to formulate the question before that. We are not even remotely suggesting that you do that. But this is a judicial order passed by a coordinate bench. But binding.
Now today, your lordship, we were not party in that somebody moved. I'm just giving a reply.
Gosh, you are such an esteemed
My lord, I am
counsel,
not,
and
my lord, my knowledge.
in one of the foundational streams of law, which is civil law.
No, I'm sorry, my lord. I'm not that, my lord. I'm just learning till today, my lord.
No.
And I think myself, I don't know anything, my lord. Honestly, I'm speaking.
That's your humility.
No, I don't know.
We appreciate that.
What I find, my lord, with great respect to your lordship, that there is a judgment passed by this court, Now judgment says that a cabinet has to take a decision. That judgment,
No. Judgment said taking into the concept of tradition, etc. In those places where traditionally it is there, let the government take a decision.
now government has taken a decision.
Now the issue before the court was whether bullfights can be allowed.
My lord,
The issue before the court
No, I'm
is
sorry.
what are the
My lord,
provisions of the
no, why
1960 Act?
at that relevant time, the government comes up before the court when the matter is pending.
Whatever. it
No,
may
no,
be.
let me explain. Let me explain. They comes up before the court and say, look here that we are taking a decision, cabinet decision. Then say, okay, you take a cabinet decision. You take a cabinet decision. That's what the view. You take a cabinet decision then.
No. Where is the occasion to take a cabinet decision?
That's why your lordship will say this. How can they take this decision which is a violation of this act?
Because of the liberty granted by the court. Because of the liberty granted by the court.
What the cabinet should have taken? Cabinet.
What the cabinet should have taken is not for us to decide
No,
or
you-
even look into.
No, you
What we are saying is there is a liberty granted by the court to the
Let-
state
what liberty, my lord?
to take a decision,
So what decision they have taken?
whatever it is.
No, that is why we are here.
Is whether the liberty ought to have been granted in view of the prima facie bar.
No,
under
that is
this.
why I'm saying that please exercise. Your lordship independently can exercise. It's not that your lordship is bound. My lord, I also know mine, but I'm just telling you, your lordship, that this is not that your lordship is because a coordinate bench has passed the order. Your lordship independently is deciding about a decision
Yes,
taken.
if it is a different issue, but this issue is connected already in the realm of the order which was passed by the
This
coordinate
is
bench.
not corrected, my lord. It has been left to the hands of the cabinet to take a decision.
Yes.
How a cabinet can take a decision which they cannot do it, my lord, under the act, my lord. This is a basic challenge we made, my lord.
So you are praying for a reference to a larger bench
No,
on
I
this
can't
question?
say at the present moment, my lord.
Then
Let me discuss because with them.
do that.
I think let me also order. Let some after all. We'll take, my lord, we'll have a discussion, my lord.
Because this I see.
I see, my lord, definitely your lordship will pass a judgment on whatever. As a lawyer, I find, my lord, it is not that I have to challenge that order for review.
I'm
Or
not saying that. What
that's
we are
what I'm
saying
saying.
is that there is already an order. This is not a case where the state has unilaterally decided to pass an SOP. State was directed or given a liberty to look into this matter, keeping in mind the tradition.
But what they have done it.
Whatever they've done it.
No, that is why my lord will kindly appreciate.
No, but the question is,
Today also it
you see, the question is that state cannot be oblivious of the laws made by itself. This is a law. This is applicable in the state of Assam. So can it be understood that the state or will be given a liberty to pass any order which is contrary to the law itself?
That is why I'm here. Before I am addressing before you.
Is the question I'm putting to you that in the face of this liberty granted by judicial order, by detailed judicial order.
With judicial order doesn't mean the state, whatever they want, order has been passed, state will do whatever they like.
Judicial order did not say that these fights cannot be carried out in view of the
Why I'm telling your lordship why deliberating the matter before the court, why the court there is a submission which is made.
Whatever
Why
it
not
be.
kindly hear it?
But this
The
is not,
submission
this is
has
not
been made.
reflected in the order.
No, it has been. What is the submission made by the state? Today they are. What is the submission made by the state? Kindly see, by learned friend read very loudly that what is this submission made by the state before the learned single judge? The report has been furnished. Have they followed it? The court has never. It is a submission made before the court. And what has happened, my lord? During the deliberation, they said no. We are coming with a cabinet decision. Very well, you go with a cabinet decision. Court is not. And this, what is that? Why they are as on that there is no act? Why they are not coming with an act? They are not coming with an act. Very well, you come with an act. No problem, absolutely. Like 3 other states. You cannot issue the SOP, my lord, with great respect. You can issue SOP, but totally in consonance with this act.
Ordinarily, yes. But reading the order, the tenor of the order appears to this court at least, subject to correction, that a liberty is granted to the state to examine everything and decide.
My lord,
Being in view the bar of-
your lordship will never, your lordship will definitely give a direction to the state. Your lordship will never say that do something which is the violation of why that is, because they came up at page 161, kindly the para 7. I just read, my lord, I will not waste. The cabinet decision that may be taken shall now prevail over any of the earlier orders. Kindly see, my lord, at page 161. The cabinet decision that may be taken shall now prevail over any such earlier order as regard not allowing buffalo fight during
See
so
that?
and so,
See
and a
that?
petition any other so and so may make the applicant seeking permission so and so. So any order which has been passed, now a cabinet decision has been
That's all
taken.
right, but reading both these orders, the tenor of the order is that the court was not directing for restraining buffalo fights, but it wanted the government to look into it and pass some kind of an SOP.
So where is that? Now how they have passed it? That's why
They,
my-
the
no,
question is
cabinet
not how
decision.
they have passed
No,
it.
no,
Question is whether they can pass it in view of Section 3
no, that is why we
or Section 11.
That's why I'm troubling your lordship that they
But
cannot
their
pass.
answer to this is that the court has permitted us. We have done it.
Maybe court has permitted. Now, court, where is that, my lord? Kindly look into it.
Yes,
Court has
we'll
said to take a
continue.
cabinet
You come
decision.
back and tell us
Yes.
what you want.
Court has, my lord, the cabinet decision to be taken. Kindly see, my lord. Cabinet has approved the proposal at page 166.
We'll come back at 2.
Yes.
Come back at 2.
So only one difficulty is, I'm extremely sorry, my lord.
Sorry.
At 2 o'clock, one matter is parted which has been fixed.
All right, you take your dates if you want.
Yes.
But state, you have to come up with an explanation. How
Lordship.
you're permitted to come up with this SOP
Lordship.
in view of a categorical bar. Ban on the unless you show that the provisions have been relaxed.
Lordship. Lordship. That is fixed.
Heard Mr. D. Das, the senior counsel assisted by Mr. D.J. Das, and MS
You does.
U. Das,
Additional senior government.
additional senior government advocate appearing for all the
Take 2 months.
1 and 2. Who's for the animal board?
I look that, I have no knowledge regarding money. Dini kare kuna se? 3.
All right, let the matter be listed again. Give us a date.
Can it be after a week?
We'll have it in January.
No, not please, my lord. That will be again troubling because January they will hold against it because this SOP is indefinite for years to come.
All right, 10th of December.
Malo.
Can it be 16th of December?
16. It's not 16.
See, that's the last week.
Yes.
So,
Yeah, because
very unlikely to.
one order is there. I don't know either if so situation arises, then we can pray for we can argue on the interim. We have filed an interim application. On 16, 17, whichever is comfortable. for the court.
17 done, Malo.
All right, 17.
17.
17 December.
Lordship.
Before my learned friend starts, Lordship, in this case, record was called for, Lordship, and I am told, Lordship, today morning it has been, it was delivered in my chamber. So if Lordship, if it is possible, it may be taken up tomorrow. Otherwise, I am ready with the record. Monday possible. Yes, no. Do it. Lordship. Yes.
This matter was posted on day before yesterday. Lordship heard extensively this matter. I'm just that petitioner organization is a wholesale consumer cooperative society. Yes, yes. Some fair price shops are treated and tagged with another organization which is not registered as a wholesale consumer cooperative society. It is not according to me, I'm relying on the communication which is issued by the assistant registrar of the cooperative society. And he is telling that this society, the cooperative society is not a party because I'm addressing this issue because the representation was filed to the Deputy Commissioner of Gwalpara. He was the in charge of the Food and Civil Supply Department, and the Deputy Commissioner has forwarded the representation to obtain opinion of the Assistant Registrar. Then opinion was given to the Deputy Commissioner that this is not registered as a wholesale cooperative society and they are not legally entitled to business with the PDS articles. So therefore, his name has been struck down by the Honorable Court itself. And it was at the motion stage in the first order it is reflected.
Otherwise, also they have filed representation lordship. That matter has not been put in the that point has not been clear lordship. That the representation they have
No, representation we have filed, and representation was forwarded to the assistant registrar of the cooperative society because the deputy commissioner is not the authority to know that it is registered under what provision of the act. Lordship will find it. It is in the page number
27.
not 27, 24. On this representation, no order is passed. Nothing has been done.
That is another law.
Page number 27.
Restoration of their fair price of law.
Yes, yes, this representation are same. There's two different representation, but the prayer is same. Lordship will find the page number 23. This page number 23 will reveal that earlier there were 87 fair price shops were tagged with our organization. No order has been passed. Yes. Their opinion. This opinion is in page number 50 and 60. Sorry, 54 and 60. Now, Lordship may peruse this, it is widely clarified in the page number 60. Here, Lordship, it is categorically stated that said, the LOT number 24 of the allotment order is a fair price dealer carries and contract cooperative society registered on 31st August 2016. That sir, the state cooperative society cannot do business of PDS commodities as per the clauses of their bylaws and provision of the Assam Cooperative Societies Act 2007.
Now, Lordship, page number 61, the clause number 4. That said, if the referred cooperative, that is the fair price dealer, carries and contract cooperative society limited, is licensed, allowed to do business of PDS within the area of operation of Gwalpada Wholesale Cooperative Society, then the same shall be contrary to the provision of section 6(3) of the Assam Cooperative Societies Act 2007. So Lordship may peruse the section 6.
Optimize the root lot. When we have given this fair price in 2016 lot, we have this fair price structure private respondents lotship in the 2016 lot. And according to our affidavit lotship, distance shown optimize the route. Lotship. Then affidavit this has been filed after filing of our affidavit lotship. That is JLO, yes, yes.
No, this is page number 34.
Well, they will file
The representation is already filed. Page number 34 is there. Reply. More particularly, it is explained in the paragraph number 6.
You get your instructions here on respect of this. Why are you waiting for a court's order? Why can't you have these instructions?
I can take it.
Then why do you need the court to tell you to take your instruction?
No.
Then
I'll take it.
May I suggest one thing, Submit Lordship? That, Deputy Commissioner may be directed to dispose my representation with reference to
let
the.
us first find out what is their instruction here. Mere order of disposal, what will you get out of it? Bring it on Monday. Why?
I'll take it. On the next final.
We'll have it on 17th. Sorry, on 9th.
9 December.
9 December.
Okay. Instead of 9, any other day, 10, 11, 12.
11.
Oh, Lordship.
List on 11th, on which date the council for the state will obtain instruction with regard to
Page number 54 and
the
60.
60 laws.
opinion with regard to the communication dated 27th of October 2016 issued by the Assistant Registrar of Cooperative Society, wherein the Deputy Commissioner was informed that the private respondent number 5,
Lordship, this respondent.
Devin Strako,
Yes.
that the fair price dealer carriage and contract cooperative society limited, to whom where is the allotment number? Where is the allotment order?
Lordship will find it in the page number 47 and 48. Entry number 24. Page 48, entry
Whereby,
number 24.
Part of the fair price shops, which was earlier allotted to the petitioner, has been allotted to the same fair price dealer, carriage and contract Society Limited. In the communication issued by the Eastern Registrar of Cooperative Societies, the concerned DC was informed that the said cooperative society, namely Walpara Wholesale Consumers Cooperative Society Limited, is not permitted to do business of PDS commodities as per clauses of their bylaws and the provisions of the Assam Cooperative Societies Act 2007. So, here, learned government advocate representing the state will obtain instructions as to the stand of the government as to whether any steps were taken in respect of the allotment order passed in favor of Walpara Carriage and Contract Cooperative Society Limited, or are required to be taken pursuant to the communication dated 27th October 2016, passed by the Eastern Registrar of Cooperative Society. The government advocate will complete his instructions of this communication and the steps required to be taken by the DC, if any, concerned DC, if any, and apprise the court on the next date fixed, placed on 11th December. Mr. Hafzat Mozumdar replaced for the writ petition. Yes. Yes.
Learned friend has completed my lordship. Lordship, see that application, my lord, that was made on 10/1/2015 to the circle officer, my lord, to grant of ownership right.
Then one,
Page number 13, my lord.
page number 13.
13.
Yes.
This is the application, my lord. He has asked for ownership right. Of course, it is written like provide Miyadi Patta, but actually it's a ownership right, my lord.
This is under the
Under
Tenancy
the
Act.
Tenancy Act, section 23, my lord.
Tenancy Act.
Section 23. 23(1). I prepared a list of dates for convenience.
Temporarily settled.
Temporary. Acquisition of ownership rights and liquidated rights by tenants, any occupancy tenant personally cultivating the land of his tenancy, desirous of acquiring the ownership rights of his landlord, may at any time make an application in writing to the deputy commissioner, and on application being made and compensation as provided on the section 25 is determined and paid by the occupancy tenant, the deputy commissioner shall declare the said occupancy tenant to have acquiring ownership rights free from compensation. Now, lordship, you will see that as per Khatian, that 2 biga and odd land was there, my lord. But he claims ownership right in respect of only 1 biga, my lord. that schedule of land, my lord, a piece of land measuring 1 biga. So out of 2 biga land, my lord, he claims only 1 biga, my lord, land. And thereafter, he has, my lord, the lordship will see there, my lord.
You show us the provision
Yes.
under the act.
I'm showing, my lord. Only he 4 kata 5 lassa he has. That is what I have proposed to sell to a third party. So he had chosen that 4 kata 5 lassas only, not any other plot of land, my lord, which he unable to show to the at the time of spot verification. Now there was, my lord, 3 spot verification, my lord. My friend has not annexed the first inspection report, my lord. I will submit that, my lord. First inspection report. That lordship also will file record page 39, my lord, in the LCR, my lord. I'm
Report.
This is the page 39 of LCR. There was first inspection report, my lord, circle officer 24/10/2014. As the lordship got it.
2810,
24/10/2014.
2410-2014.
Of course, I'm given an English type copy, my lord, vernacular. In connection, may I read, my lord? In connection to the above stated matter,
Oh, you have an English copy.
I have given a translated copy, my lord.
You don't have the original.
No, that is a report of the circle officer, my lord.
That's in vernacular. Do you
But-
have the original copy? No.
No, my lord, it is a part of the record, my lord.
So page 39 that you have pointed out is in vernacular.
Vernacular. I typed it, my lord. I've given that.
That we have, but do you have the copy of this vernacular with
Yes,
you?
I have.
You may read that.
I have that.
You may read it.
But that's why I typed it in English, my lord. But my friend can read it, my lord.
Read it. No, which part of the land?
Total that.
So entire 6 biga.
6 biga. Actually, total area is 6 biga, my lord. Out of that, 2 biga has been carved out of my lord.
Putro. Senira.
ইতিমধ্যে খাতিয়ানদাৰ প্ৰত্যেকীয়াৰ পুত্ৰ এগিলাম চুতীয়া বৰ্তমান মৃত্যু হৈছে। তেওঁ দুজন পুত্ৰ ক্ৰমে অন্তচুতীয়া আৰু সংশ্লিষ্ট লাভমন্ত্ৰ আৰু গোটাই বৰদলীৰ ক্ষেত্ৰত কৰি দাখিল উল্লেখ কৰিছে। নামত 49 নং দায়কে খেতিয়ান যোগে লাভ কৰা চাপে 10-2 নং কাগৰ বিঘা 11টা সফল দেখা নাপালে সংশ্লিষ্ট লাভমন্ত্ৰ আৰু গোটাই বৰদলীৰ তদন্তৰ হিচাপে There are 5 brothers, my lord, as per the first report, my lord. But only Dhaniram has filed this case, my lord. And it is mentioned, my lord, that no position of Khatian holder was found that time, my lord, when spot verification. And it is also been specifically mentioned that
No, Khatian was there.
yes,
But the land could not be identified.
they have never done any agriculture from 71, my lord. That at the time of survey, the legal heir of Lakhiram Chutia, that is Dhaniram Chutia, who was present, was unable to show, my lord. So he could not show. Then there was a second report, my lord, which he has annexed, my lord. Second report, lordship may find it, page 23.
23. 23 of the record.
Record. This writ petition, my lord.
Huh?
Writ petition. But I want to show the land, my lord. That land which is involved, my lord. This is the photo, my lord.
Photographs. How do you connect this photograph to the land in question?
That is, my lord. That is the land, my lord. Lordship can make an inspection also, my lord.
Why should we go and make it?
I'm just saying, my lord, but this is the land.
Yes.
Then number second report, my lord, 12/8/15, my lord, page 23, my lord. Here also, my lord, lordship may read the second paragraph, my lord. Of course, vernacular is there next page, my lord. During the course of time, aforesaid land was sold jointly by Akon Kalita, sold to Akon Kalita, Savitri Kalita, Moni Kalita in the year 1974-75 as per the order dated 28/5/8/75 in the mutation case number 139. Their names were mutated by virtue of purchase. On the other hand, the class of land of the aforesaid act has been converted to residential class as per order passed by the Deputy Commissioner on 5/5/95. Therefore, it is not known how the class of the land of possession Dhaniram Chutia as a Riyate Khatian holder has been changed and whether the Riyate Khatian holder has renounced his position over the land. Previously, during the spot verification, the applicant could not show his position over the land. Then thereafter, again on 29/6/15, as per order dated 24/6/15 passed by JEC, when spot was visited by investigation, the land measuring 4 kata 5 lachas of the aforesaid tag was found to be under possession of Riyate Khatian holder along with the Paka boundary walls. That is mentioned under that. Then let's see the next parameter. On the other hand, as per information of the Pattadar, the aforesaid land boundary was bounded by Paka wall was under possession of Srimati Manjula Datta and Shri Arup Datta. During the time of investigation, we did not find any cultivation of crops or other agricultural activities. The said aforesaid report is submitted on the basis of report submitted by lab. So this is the third report, my lord. I'm sorry, my lord. The second report is at page 16, my lord. Page 16, Your Lordship may see. The writ petition. With reference to the subject cited above, may I read, my lord?
Yeah.
I would like to inform you that in the Jorhat Revenue Circle Town, Moja 3, block number 14, a plot of land measuring 6 bighas, 4 katas, 6 acres covered by Ismail Patta number 9, tag number 2. So Gautam Kalita and Raju Kalita, both whose father was late Akam Kalita, along with 6 other Patadas names were issued in the petition. According to the present land record, the above mutated land of tag number 19224, measuring 6 bighas, 4 katas, 6 acres, was already purchased by Sri Gautam Kalita's father, Sri late Akam Kalita. According to the report of Lat Mandal, in between the plot of the above named Dagland, an area land measuring 2 bigger 2 katas of 6 acres, Sri Gautam Kalita and Sri Raju Kalita has partially constructed a pakka house, and in the remaining part of the man-made waterless pond has been created and fenced around. The land sold by the above named Patadar measuring 4 bighas 2 katas. In that part, the other Patadas have taken into possession by constructing pakka posts, that means the Manjula Datta matter, around it. Except Patadar Riyati Khatan holder are not having possession of the above named tag. Is no power to do condition and no proper condition to do agriculture. So the land was never on a condition, a proper condition to do agriculture. Madam. So he two report he was not satisfied, my lord. Then again is the third report was called where that observation is there, my lord. Now lordship may see the how he will acquire, my lord, pakka khatan because the procedure has been laid down.
Yeah, come to page number 61, the impugned order.
Yes,
There you find the fourth paragraph.
my lord. The learned
Ah,
the learned Deputy Commissioner Jorhat, after hearing the both the parties, was pleased to grant ownership right of land measuring 4 kata 5 letters, tag number so and so, patta number 9, block number 14,
So-
Jorhat town.
so against this you had come before the revenue board.
Yes,
And revenue board passed the order which is
Yes.
put to challenge. Now
Yes.
this additional deputy commissioner Jorat, at the time of hearing, there must be some report available under the,
No,
by
my
the
lord.
circle of the.
my lord, that time when I conducted
Where is that order?
which one, my lord?
The additional disease order?
Yes, additional disease order is page, my lord. Page 38. Subsequently, my lord, the agency was arrested also, my lord. May I read, my lord?
Hmm.
Petitioner Shri Dhaniram Chutia, son of late Lucky Chutia, who was the Riyati land 2 bighas, 11 letters under tag number so covered by so of Jorhat, the Moja filed a petition for ownership right over the land measuring 1 bigha, 0 letter, for which hearing is on so and so. Heard learned advocate for both parties. Learned advocate for the both parties challenged the Riyati Khatian issued from in form number 19. He argued that this is a draft Khatian and argued only in the procedure issue of Riyati's Pakka Khatian. Riyati's Pakka Khatian is issued in form 19. The petitioner submitted certified copy of Khatian in the which Riyati Pakka. He has changed the word into Riyati Pakka Khatian. Is not stated, it is stated Riyati Khatian. As a Khatian issued it as per provisions of Tenancy Act 71 during the year 1974. So the certified copy of the Khatian is proposed to be a valid document as per Section 79 of Indian Independence Act. And the opposite party could not prove that the Khatian issued more than 40 years ago is an incorrect document, and the Khatian is issued by a Dadan settlement officer who is a public officer and as per provision of Section 74 of Indian Evidence Act is presumed to be public document, and public document issued more than 30 years could not be challenged. So totally in a wrong conception, because a draft Khatian is always remain a draft Khatian. It cannot become a Pakka Khatian by law. As per the learned advocate of the opposite party could not prove the non-occupancy of the tenant in the dispute land circle officer's report submitted by letter dated 24/10/14 has been rejected by this court and call for a fresh report, and circle officer Jorhat East Junior Circle submitted report dated 13/2/15, on which the petitioner already filed an objection stating that at the time of spot verification of the land, no any notice has been issued to the Riyati Khatian by the circle officer mentioning the date and time of spot verification, and petitioner paid for verification of the spot and the circle officer report dated 12/15. It is clearly stated that land measuring 4 kata 5 latches is under possession of Riyati, but Pattada said that land is under possession of Srimati Manjula Datta, wife of so and so, but not in possession of the Pattada himself. According to Guwahati High Court, judgment date is a Arakanta Deka address so and so, stated dignity of landlord of tenant collective has name been recorded in Khatian as occupancy tenant. Once name of tenant is recorded in Khatian as occupancy tenant, Pattada landlord would not be entitled to discuss the position of such occupancy tenant over the land. So as stated in the circle of the report that Pattada says that land is under possession of one Srimati Manjula Datta could not be entertained as per ruling of the stated above. So considering all the facts stated above, the court is pleased to grant ownership right to the land measuring 0 figure 4 kata under land number so and so covered by so and so. Block number 14, Jorat Town 3. Moja has been granted to the petitioner Dhaniram Chutia, son of late so and so. Jorat Revenue Circle will take necessary steps to correct so and so. So this is the order. Now in this, there my lord, we have placed the judgment. He has not bothered to place Pulin Boro judgment in this judgment also. He has somehow, we don't know, madam. He relied on judgment which is not relevant to the instant case, my sir. There is an occupancy tenant he has been declared. There he considered that judgment, but Pulin Boro judgment he did not consider, madam, although that was placed before him, madam. Now, lordship, so far,
This Horokanto is also division bench judgment.
no, Justice Suman Shankar, single bench judgment. Now, lordship may see how the land, the procedure for preparation of records of right. Now, lordship, I'll rule 28 may be seen, man. Tenancy rules. There is a proper procedure, my lord, for preparation of record of rights. Rule 28, my lord. First, my lord, how the survey has to be made. It is there, my lord, when an order has been made under Section 55 of the Directive the Record of Rights, shall be prepared with survey. The survey shall be made as provided for under the regulation. Then 29A, the various procedure has been laid down, my lord. That is, now lordship will see Rule 30. May I read, my lord? Rule 30. After the boundaries of all the holdings of the tenants have been surveyed and demarcated, a draft chitta field index shall be prepared by the landlord staff under the direct supervision of the assistant settlement officer. The chitta shall be arranged according to the serial number of the plots in the map, shall the name and residence of the tenants, area of plot, length of possession of the holding of each tenant, the amount of rent in addition to any other particulars as the state government may direct. Disputes regarding the boundary of the holding shall be decided on the basis of actual possession. Then Rule 31, my lord. Record of attestation and local explanation. The assistant settlement officer shall then cause draft Khatian to be prepared from the chitta. The Khatian shall be in Form 19. So this is Form 19, manner which he produced. In addition to the particulars included in the chitta, the Khatian shall also contain the landlord's name, address, and the number of patta held by him and the revenue payable in respect of the plot. There ordinarily shall be separate Khatian for each tenant under the same landlord. Where, however, a tenant is found holding different plots under separate landlord, there shall be a separate Khatian in respect of each and landlord for that tenant. Number 2. Before record of attestation of particular begins, each tenant and his landlord shall be furnished with a copy of the draft Khatian. The record attestation of each area of the village shall be taken up in the near the area of the village, and sufficient time have been allowed to the tenant and the landlords to study their copies of Khatian. The proclamation shall previously be published in the village concerned notifying the landlord and the tenants appear before the assistant settlement officer with their copies of draft Khatiyan. As each copy of draft Khatiyan is produced before him, the assistant settlement officer shall examine the entries therein and shall read out and explain the entire, make corrections wherever necessary. Despite dispute regarding the ownership of any tenant, fully shall be decided by the assistant settlement officer in a summons manner and on the basis of actual position. All the objection and question to the correctness of the entries in the Khatiyan, particularly those relating to the rent and the class of tenant, shall be decided in like manner. It shall be the duty of the assistant settlement officer to attest correctness of all entries in the Khatiyan, irrespective of whether any of the entries may or may not have been disputed. Then publication of draft record. After attestation, after record attestation, the assistant settlement officer shall correct the records as per orders passed in the course of attestation and prepare the draft record of rights for an area of village. The assistant settlement officer shall thereafter publish the records during a period of not less than a month. A convenient place he may be determined. A proclamation shall previously be published in the local area or village informing the landlord and tenants of area of village and place at which and the period during which the draft records will be open for public inspection and the last date of filing objection. So, notwithstanding anything contained in the proclamation, the settlement officer may extend the period of inspection of the record and record and filing of objection. Then objection has to be made. Rule 33. Blank forms of objection shall be supplied free of charge unless otherwise decided by the state government, and objection shall be, as far as practicable, be in Form 20. And such objection shall be filed before the assistant settlement officer having jurisdiction over the area. Along with the original objection, the objector shall also file sufficient copies of the original objection as may be required for the service of the opposite party or parties and such other persons who, in the opinion of the assistant settlement officer, are materially interested in the case. The assistant settlement officer shall hear the parties at all and all such persons who are interested on the date and place fixed for hearing of the objection. Generally, the assistant settlement officer shall record an abstract of the reason for decision and the record shall contain the names of the witnesses to be examined. No objection shall be disposed of in the absence of any interested party or their authorized representative unless the assistant settlement officer is satisfied for the reasons to be recorded in writing that the notices were duly served on all persons concerned. Then 2. An appeal shall lie to the settlement officer having jurisdiction over the area from the order of decision of an assistant settlement officer under subject 1 above if preferred within 2 months from the date of the order appeal against. No appeal shall be disposed of in the absence of any parties materially interested or their authorized representative unless the settlement officer is satisfied for reasons to be recorded in writing that the notice were duly served of on all persons concerned. Then Rule 34, preparation of final record. When all objection under Rule 33 have been disposed of and orders have been passed on all appeals to the settlement officer from the orders of the assistant settlement officer and draft records corrected, where necessary, the settlement officer shall proceed to frame final record in strict conformity with the draft record already attested or subsequently corrected. The final
Who is to adhere to the procedure? That's right. Who has?
DC, man.
And
The Lordship may see.
if the DC doesn't proceed, how is it the fault of the Khatiyan holder?
Lordship may see the 57, section 57 and 58, my lord.
Page number.
In this book, my lord.
Okay. Rule 57.
Section 57. The 58 is the final draft. Now, section 57, before that, my lord. May read, my lord.
Yes.
Preliminary publication, amendment, and final.
No. What we want to know is that once there's a draft Khatiyan, for the draft to be reduced to a final Khatiyan, the procedure prescribed has to be followed by the DC. Now, if the DC did not proceed, how can the rights of the Khatiyan holder be come under a cloud? Because the nature and class of the land has been changed, so it has not been cultivated, etc.
Even second order has to be, my lord, because there is, if the father dies.
Under the provisions of this act,
Yes.
once you have a khatiyan, you have some right.
Yes,
Unless you say that subsequently, when the process for doing a final khatiyan is there, it was found that land is altered or is not there.
for that reason, lordship may come to section 7 and section 8. That is devolution of death, right of transfer. So it is, there's devolution of death, section 7, my lord. If a tenant dies intestate in respect
No,
of.
is it your case that there was no khatiyan?
No, there was khatiyan, but it was a draft khatiyan.
So now who is
So,
responsible
no,
for
therefore, my
giving
lord,
the final khatiyan?
final khatiyan is authority, my concern, or the
If
tenant.
the authority
tenant
has
is
not
also.
done it, the authority has not done it, then how is the khatiyan
No.
holder responsible?
Khatiyan, they are also equally responsible, my lord, because.
Unless it can be shown from the record that in spite of requirements being sought for from them, they fail to respond to the
There's
notification.
nothing in between, my lord, that they have tried for change of ownership or khatiyan. They have never done any, except that application they filed.
Assuming there is a draft khatiyan also, can it be said that no, this draft khatiyan does not give them any right?
Yes, lordship will see the judgment, my lord. That is 2007 GLT, but I prepared a written argument, my lord. In that the judgment is pleased, my lord.
Pulinboro.
Pulinboro.
Yes, please read.
Yes.
Relevant portion.
Lordship got it? Or
Yes.
para 3.
Hmm. Yes, please.
The appellants claiming themselves to be occupancy tenants.
Hmm.
Tenants under the erstwhile landlord was defined by the Assam Temporary Settled Areas Tenancy Act 1971, hereafter referred to Tenancy Act, and maintained that the land in their occupation had been declared as semi-surplus land of Assam Fixation of Cleaning of Land Holding Act 1956. According to them, they were thus entitled to have the settlement thereof in accordance with the provisions of Section 15 of the Cleaning Act, while the process of the settlement in their favor followed the deposit of allotment fees as referred to them at the final stage. The same is endeavored to be allotted to respondent 4. Now 4. Elaborating on the claim status of occupancy tenants, the evidence are averred that they and their ancestor were tenants under the Parmatar Bora and his brother Lucky Dhar Bora, who held land measuring 323 bighas 2 kathas 80 lasas in their name in Sinduri Gopa Moja in the district of Kamu under Patan number 1. They have stated that they are agriculturists individually cultivating the land owned by the above named landlord. They have asserted that they are occupancy tenants and had been issued khatiyans by the competent revenue authority under the Tenancy Act. The khatiyans contain the names of their landlord and the other particulars of the land. In the year 1976, 280 bighas of land held Padmadar Bora was declared as ceiling surplus under the Ceiling Act. The appellants were some of the agriculture occupancy tenants on the land and declared as ceiling surplus land and were entitled to the rights of ownership under the Tenancy Act as well as to have settlement of the land held by them under the Ceiling Act. Accordingly, all of them applied for grant of ownership right under the Tenancy Act, but their request remained unresponded. Now, the government, however, followed the acquisition of land under the Ceiling Act, required all the executive tenants, including the appellants, to deposit allotment and conversion fees for the purpose of settlement of the land involved. Though the appellants, along with others, deposited the allotment fee, they were neither conferred with the ownership rights nor granted settlement of the lands in their possession, in spite of the compliance of all stipulation of the so and so. Then Lordship has a para 5. The respondent number 2 and 3 in the written response, while admitting that the appellant's possession of the land in question, considered that some of them had been issued kacha during the last annual tenancy resettlement operation of the district, asserted that no final khatiyan had been issued to them and that therefore they were not the recorded tenants of the landlord under the Tenancy Act. The answering respondent with reference to the relevant records have averred that the Deputy Commissioner Kamrup Guwahati had issued allotment certificate to the appellant only in the year 76 on the basis of the position of the land involved, and some of them had been paid premium for settlement of the land in the occupation. The respondents also admitted that the appellant and some other ancestors were tenants of former Pattadar from whom lands measuring 323 biga 2 kata 18 rachas had been acquired under the ceiling Act in land ceiling case shows. They, however, reiterated that no final khatiyar had been issued to the appellants who continued to cultivate the land even after such acquisition. According to them, therefore, the appellants could not consider for acquisition of ownership right under the 23 of the Tenancy Act, as they were not the recorded tenants at the time of acquisition of land ceiling Act. Now, I will skip that matter. Lordship may come from para 14. Para 14, madam.
Yes, yes,
The very madam.
yes.
The competing arguments have been duly considered. The appellant's challenge at the cost of reputation is founded on the following consideration. They were occupancy tenants under the original recorded Pattadar, Parmadar Bora and his brother Lakidar Bora. They had been issued Kata Khatia. They had applied for ownership right under the Tenancy Act. They were cultivating tenants in the position when the land was acquired by under the Ceiling Act. They were issued allotment order certificate. They had been conversion fees premium so and so. Now 15. The Tenancy Act in terms of two thereof does not apply interior to the land owned by the union or state government or local authority, which is used for many public purposes. The statute classifies tenants contemplated under the two categories, namely occupancy tenant and non-occupancy tenant. A person who, for a period of not less than 3 years, has continuously held land as a tenant would have a right of occupancy in that land, as specified by Section 5. An occupancy tenant is acknowledged to have permanent and heritable right to use and occupancy of the lands in terms of Section 3. First, this right of occupancy of if a tenant dies, intestate devolves on his death. Section 21, 22, and 23 deals with acquisition of the intermediate rights by the tenants under the tenants under Section 8, but in particular an occupancy tenant cultivating the land of his tenancy and acquiring the ownership rights, landlord may at any point of time make application in writing to the commissioner and thereof determine the payment of compensation. The deputy commissioner district would declare the said tenant to have acquired ownership right free from all income tax. Then para 17, man. Under chapter 7 of tenancy rule deals with the procedure for preparation of record of rights. Rule 29A indicates that the various stages of the process under section 30 of the mode preliminary survey, that is, it should be rule 30, madam. Rule 30 of the mode of preliminary survey and record writing is provided. Thereunder, after the boundaries of all the holdings of the
This land in question, was it under ceiling surplus?
no. Thereunder, after the boundaries of all the holdings of the tenants are surveyed and demarcated, a draft chitta or field index shall be prepared by the landlord staff under the direct supervision of the assistant settlement officer. The chitta would be arranged according to the serial number of the plot of the map and would show the name of the residence of the tenant, the area of the plot, the length of position of the tenant, the amount of rent and necessary particulars. Thereafter, the assistant settlement officer would cause draft khatiyar to be prepared from the chitta. The khatiyar, in addition to the particulars in the chitta, would be also contain the landlord's name, address, the number of patta held by him, and the revenue payable in respect of plot of each tenant and his landlord would be furnished, and it in the process of record of attestation that would follow, assistant settlement officer would hear and decide the dispute, if any, with regard to the notice appearing in the draft khatiyar. After the necessary corrections and attestation, the assistant settlement officer would prepare and publish a draft record of rights in the local area or village, informing the landlords, the tenants concerned about the same. Finally, the records of rights will be prepared for all objections raised with regard to the draft records have been disposed of
and the appeals from the orders of the assistant settlement officer are decided by the settlement officer and essential corrections are made, the final record of rights of an area, a village would be published, and a proclamation informing the landlord, the tenant of the place would also be made, disclosing that the final records were open for public inspection. A certificate of final publication will be furnished within a month of the last day of final publication of the records of rights. A combined reading of the above provisions of Tenancy Act and the Tenancy Rules proclaim that a kacha khatiyan or a draft khatiyan is not a definitive significance vis-a-vis a person in cultivating possession of a land governed thereby. In view of the comprehensive procedure for preparation of record of rights under the rules of the appellant, claim of occupancy tenants under Padmadhar Bora and Lakshidhar Bora at the time of acquisition of the land under the Sealing Act thus cannot be adjudged to be absolute, unqualified, and conclusive. The appellants have not accepted their right. Name of occupancy tenants had been incorporated in the final records of rights. No assertion has been made either that any process of preparation of record of rights under Chapter 7 of Tenancy Act at all been undertaken involving the land in their occupation. The materials available in record, on the other hand, only demonstrate their categorical case of being issued kacha khatiyan. In that view, the matter, the stand of the official respondent that the petitioners were not recorded tenants and thus not entitled to be conferred with ownership rights under the Tenancy Act or settlement of the Sealing Act cannot be likely. This is the finding matter.
But this judgment is with regard to the claim of compensation to be sought for in respect of ceiling surplus.
Procedure has to be followed by the Rule 31, Rule 30, draft and then the publication under Section 58, 57. Now, I'm reading Section 58, the finally will be published under Section 58. So Lordship may see.
This petitioner before the court, one of the
One of the such out of the 5.
what
And
happened
one
to the other 5?
Seniram, no, there is no mention of them 5. No, nothing. One expired. He got 2 sons.
What happened to your brother?
My lord, they have instructed me to go for the ownership, my lord. There is no written.
No,
4 persons, 4 sons.
This plot of land which you are claiming,
4 katta.
you are claiming on your own behalf or on behalf of all your brothers?
Nothing is there on the petition.
As a legal here, I am claiming.
No, that is not there.
For whose behalf? Your behalf.
But it is not mentioned.
Your behalf. Otherwise, it is your behalf.
Yes. Lordship says Section 58 may be seen, my lord, that ultimately final publication will be made under Section 58, my lord. Certificate. Tenancy Act. 58.
58.
Certificate of and presumption of final publication of presumption as to correctness of record of right. Where a record of right has been finally published under Section 57, the settlement official shall, within such time as the state government may be general or special order, require or make a certificate stating the fact of such final publication and the date thereof, and shall date and subscribe the same with his name and official. The certificates of final publication or in the absence of the certificate, the certificate signed by the deputy commissioner of a district in which he stays, or a part thereof is the record of rights situate. That record of rights has been finally published on a specified date and shall be conclusive proof of such publication as the date thereof. The state government may by notification declare with regard to any state or that a record of right has been finally published in the village which the state situate as a state to also. This is more. The findings of the
for the code of review, my lord. Your lordship, you may see the last page, my lord.
Where is the judgment Horokando Teka? Is it available?
That is in the spectrum of occupancy clearance, my lord. I have a copy of the judgment.
You have that copy of the judgment?
But I have a type of, but from the net I have taken out. This is RSA 22 of 2004, my lord.
It's not a reported case.
Uh,
2015 4 GLT. 4 GLT 282. 282.
This is my lord. Actually, what happened, my lord?
Additional PC has given him the benefit of open tenancy on the basis of that. Revenue Board has referred to many issues.
Yeah.
They'll be change of the nature of the classification of the land, the draft khatiyan or the final khatiyan. Perhaps one view possibly could be that the matter could have been remanded back to the DC to examine all these aspects.
No, lordship may see the DC has also paid 63, my lordship may take.
63.
3.
Okay.
The second line, my lord, the respondents. The respondent did produce a copy of Khatiyan under Form 19, which is a draft Khatiyan but could not convincingly establish the final record of right.
What is the meaning of that?
Because draft Khatiyan and Taka Khatiyan, he could not. And then, my
Draft
lord,
khatiyan does not establish a record of right, is one view. Draft khatiyan does not convincingly establish. What is the meaning of convincing?
that is like that is not established, my lord. Rather, it's a plain word is not established. And lastly, my lord, the DC has said, however, the party is liberty to approach civil court for judicial grievances. That is the appropriate court, my lord. Lordship, see the Khatiyan, my lord. Draft Khatiyan. That is issued for 2 years, my lord. Whereas occupancy tenant, he has to be at 3 years, my lord.
There is a categorical view of this court that once the name is recorded in a khatia, landlord would not be entitled to disturb possession.
But here that draft Katian and Kasakatian never been a question matter.
Huh?
That is not been question matter, draft Katian or Kasakatian.
That's right.
But
There
we
is
have
some
specific.
khatia. Khatian is also contemplated under the Act,
Yeah.
which is the first step.
Then the final Katian is also there, my lord.
Correct, but not a case that description of a khatian is only with that final khatian. There is a draft khatian. Why it did not get converted into a final khatian is for the revenue officer's side. The records will be for what orders were passed or not passed, the different thing. But there was a khatian. So there is some evidence to show that they were in occupation of the land.
But one thing is that, my lord.
We are just trying to understand because the revenue board has interfered with the order of the
Yes.
but this was not on the finding, not on the view that draft khatian and draft khatian alone is not sufficient. There is no finding. Or that is contrary to the act of the there is no finding.
Then it is to go to the deputy commissioner, my lord.
Ought to have got. Ought to have got. Because these are matters of record. On what basis the deputy commissioner had granted the order, how it was done, etc. These were not looked into. What was looked into is that the classification of land has been changed, and yes, some, and also, if you see the order, the respondent counsel is not present. Page number 61, second last.
I have seen that. I've seen that.
So,
That finally, liberty was given to approach civil court, my lord, because and at no point of time, my lord, Pakka Katian was produced, although they are saying Kasa Katian to be a Pakka Katian. We filed objection, my lord. Lordship may see in the record that it was remained for objection. We filed objection also that he is simply, my lord, he is Kacha Katian. He is saying it's a Pakka Katian.
yes. Anything?
Well, this document I have annexed here, well, though it's not very clear, well, here in the certified copy, it is reflecting it's the Khatian Pakka Khatian. Well, though the form number is 19, I agree to that. But so far as the compliance of this, all this section, rule 31, draft Khatian, converting it to the final Khatian, those exercise, whether those were done or not by the DC, right, can best be, apprised by the DC himself. Well, better course, in my humble sum, it can be remanded back to the revenue board to deal with this aspect. Because so far as the revenue board order is concerned, it is also perverse because of non-consideration of the report, the last report submitted by the circle officer, where it clearly shows the possession of the petitioner.
Where is the last report?
Last report, page 23, my lord.
But what do you say about the change of the classification?
Change of the classification, my lord, I have already submitted a division bench judgment. Change of class, my lord, doesn't make any embargo on the part of the authority to grant the ownership right. The last, my lord, this judgment I relied on of the division bench, it is very clear. And it has been followed in one of the single bench judgment, that is WBC 660, passed by Honorable Mr. Justice Rishikesh Roy.
Where is that order?
It is on the record, my lord. I have submitted last occasion.
Oh.
Here the judgment of
Is order
Sodo
dated,
Assam
order
Patadar.
dated 16/6.
Yes.
What is particular of that?
Particular last line, the relied on
No. What is the case number, etc. Name?
WBC number 660 of 2010, Bikram Hukum versus State of Assam.
2010. Bikram.
Bikram Hukum versus State of Assam. Order was passed on 16/6/2016. In the judgment, the division bench judgment of Sodo Assam Pattadar Sangha was relied on and came to a finding that even if the class of the land is changed, it doesn't create any embargo on the part of the authority. Or it
And what is the judgment of division bench, another division bench judgment, 1990? Niranjan Borua.
yes, this is Niranjan Bola Sodo Assam Pattadar Sangha, 1991 JLR. It says about the class, even if the class of the land is changed, it doesn't disentitle the occupants to claim for ownership rights. It says in paragraph 14, it is true that the Act does not contain an express provision to the effect that rights secured under the Act would not be taken away by the inclusion of any area in the civil station.
Paragraph?
Paragraph 14, Mal. Starts with the effect of amendment in section 318 of the Act is that no occupancy tenant can be claused with the right conferred by section 23 after doing so with respect to the land included. Then relying on some of the judgment, Lavanya J in Monor in one of the paragraphs, quoted paragraph 9 of one of the judgments, quote and unquote, it is true that the Act does not contain any express provision to the effect that the right acquired under the Act would not be taken away by the inclusion of an area in the civil station. Well, in the single bench judgment WBC 660,
This is with regard to some amendment brought in.
well, this is the amendment. This is the amendment saying
Yes.
and this same judgment was relied on by the this Honorable Mr. Justice Roy's judgment, WC 660, which clearly says, my lord, even if the class of the land changed, because here the dispute was one of the lands, my lord, which was agricultural land, it came under the Guwahati municipality area. There the dispute arose whether this land would be covered under the Section 23 application or not. Here the specific finding was relying on the division bench judgment that no, even if the class of the land change, it doesn't extinguish the right of the occupants to claim for ownership right. And here, so far as the submission by the Learned Senior Council is concerned, my lord, this non-observance of section 57, 31 exercise, these are the exercises to be done by the Deputy Commissioner. And in the judgment, Revenue Board judgment, there is clear perversity for non-consideration of the report submitted by the cycle officer. When the learned member came to a finding that I am not in possession, well, it is in contravention, it is in contrary to the report submitted by the cycle officer, the last report. In view of that, it can be remanded back to the Revenue Board to decide.
Twice the report had come that he was present, he could not show, subsequently, he third report he showed that there also there was finding that one Manjula Datta was in possession of the land matter.
But this last report was not considered by the learned member of the court.
Okay. Anything more?
No.
Lordship can see 37 and 38 section, my lord, that is the rent receipt and deposit of cash, rent of money. So there's nothing has been, my lord, pleaded or they have reduced evidence in that respect, my lord. The rent receipt section 37, my lord,
every tenant who pays his rent shall be entitled to obtain forthwith from his landlord a written receipt signed by landlord or his authorized agent. Then 38, deposit of cash rent or money issued. When a landlord refuses to accept any rent or tendered by him by a tenant, or when the tenant is in bona fide doubt as to who is entitled to receive the rent, the tenant may make an application to the revenue officer. So nothing is, they have not established that part. I said procedure has not been followed.
Well, then section 51, it says a ground of ejectment. Well, if it is the case, well, then the
They were
respondent.
never in position, there is no question of, because the land is under the boundary wall, my lord, Kolkata. Then not fit for agriculture, that has been said by the circle officer report, my lord. Two reports says, third report does not say, but two reports says that it is not fit for agriculture. There was not agriculture any point of time. I'm holding this land 75, I put a boundary there. Now he is claiming that this land should be granted as ownership right.
But well, they have not challenged my Khatian, my lord, till today. And there is no suit, my lord, decree sought for eviction, my lord, as contemplated in section 51, grounds of ejectment, Assam temporarily settled areas 1971. It can be remanded back.
Because according to them, you're not even in possession.
No,
Where is this
But the last report is something contrary to their submission, my lord. Well, the last report says I am in possession.
No.
There is no objection to the last report.
Why should I objection? It is written on the other end as
We'll list it on 3rd for orders. 3rd of December.
and only one person, my lord, come, or brother, my lord. The others didn't challenge.
It is up to the siblings to decide. The others may not be interested.
But he has to say, my lord. He didn't say anything.
That would be a separate case for the family members. I pray for remand back of the matter to the Board of Revenue so that to decide. Much obliged.
Problem.
This, I think we have concluded.
He wants to say something small. He can give in writing.
Heard. We'll reserve it.
Otherwise, it will never finish.
Heard. General Counsel for the petitioner. Hearings, submissions concluded. Judgment reserved.
Can give in writing. We will also inform.
Last occasion, he
He
submitted that there is
earlier,
no separate.
earlier he made submissions. Thereafter, he said that on the basis of the written submissions, I would say something. Now he can give in writing.
We wanted to know whether there is a separate report of that.
That report is not there. That
report is not
said.
there. Right.
The other things he can give in writing.
Your written arguments are submitted.
I have already submitted.
Thank you.
I'm obliged.
Hey. Yes, we have reserved the judgment. Anything more? Itu kita pilih ke aku. Sampai ke tadi. News for the petitioner.
PM na.
Not here. Then. Next week or in January, we'll have it in January.
Whole pending order next week, my lord.
There's some interim order.
There's an interim order.
All right. Next week. List on third on third.
Can it be, my lord, on third, Monday? Third or fifth also. Fifth.
Fifth. All right. List on fifth. None appears for the petitioner. Mr. Count appears for the respondent.
Five.
List again on 5th December.
Please, your lordship. Lord,
Yes.
the repetition before your lordship, a speedy trial has been sought for as a relief, my lord. This case is pending, the trial of this case is pending before the learned special judicial magistrate since 1986. And it has been stalled due to the, as the case diary of the case has gone missing.
Charge sheet has not been filed.
Charge sheet was filed. Charge sheet was filed. Along with the charge sheet, the IO submitted the case diary. And thereafter, cognizance was taken. Summons were issued to the accused persons. And when the date was fixed for copies, delivery of copies, since that date, the case diary has been missing. And therefore, the copies could not be delivered. It is sometime in 1986, my lord. This case relates to an incident of 1985 when, in this case, there was a murder in a dacoity. Lordship will find the charge sheet.
What is the stand of the state, if at all, if any?
My lord, state has filed an affidavit enclosing a report of the Joint Secretary Home. My lord. If your lordship goes through the report, actually, my lord, in these cases, as per the Assam Police Manual, 3 case diaries are to be maintained for a case of dacoity, my lord.
No, forget about the procedure, what is to be maintained, what is to be not there.
Well, they have filed a report, no case diaries have been maintained.
All right. Now what?
Case diaries could not be, even the duplicate case diaries could not be.
What do they propose to do? Who's for the state here in the matter?
Well, Mr. Majumdar was appearing, AG, additional AG. Well, in fact, if your lordship kindly sees order dated 6th of August 2024. Well, a scanned copy of the lower court records order sheet was called for. And there has been, if your lordship kindly sees the office notes, there has been 5 occasions, reminders were issued. The scanned copy of the case record has not been sent. Well, I will not be surprised if they say that this case record has also gone missing, my lord.
Yes, Mr. Sharma. Borwa, sorry.
In
Borwa.
this matter, A. Bora was also appointed as a matrix jury, and D. Majumdar was handling the brief.
Where is Mr. D. Mazumdar?
The amicus appointed, he never remained present in any of the hearings subsequent to his appointment, my lord.
Where are the orders calling for the scan copy?
There was 6/8/2024, 6th of August 2024. It was, order was passed by Honorable Justice Mr. U.K. Nayak.
6th of August, 23, 24.
24, madam.
Why was the scan copy called for?
My lord, in fact, what had happened in the report submitted by the Joint Secretary, there was a mention that only once the special judicial magistrate in sometime in the year 2011 had called for the duplicate and triplicate case diaries. Whereas in the in reply to my RTI applications, they said that on numerous occasions they have sought for the
The court wanted to see the orders.
yes, yes. What were the orders passed?
All right, heard Mr. D. Goswami, and yes, who's appearing for?
I'm appearing on behalf of Mr. T. Mozumdar.
Where's Mr. Mozumdar?
Lordship, should be left to
Court is informed that Mr. D. Mozumdar, learned additional AG, representing the state in the matter. So, this writ petition is filed by the petitioner seeking appropriate direction to the
By prayers at page 12, page 7 of the
appropriate direction for tracing out the case diary connected to Chanmari PS case number 89 of 1985 corresponding to GR case number 1216 of 1985. And as the investigations connected to the same case culminated into filing of an FIR, filing of a charge sheet, and the matter is presently pending trial before the Court of Special Judicial Magistrate, First Class, Kamrup Metro. Stop. The grievance of the petitioner is that since the year 1985, 85 or 86?
The case diary went missing since 86.
No. Case was filed.
Case was FIR was lodged in 85.
Since the year 1985, 86, from 86, the trial has not proceeded on account of the case diary not being traceable before the court. It is submitted by the counsel to the petitioner that numerous orders were passed by the concerned trial court calling for the relevant records, but the case diary has not been placed before the court. In view of the situation, in view of the submissions made, this court earlier by order dated 6/8/2024 directed the registry to requisition scan copies of the order sheets of the GR case number so-and-so from the court of so-and-so, and the matter was directed to be listed thereafter. So, office note reflects that the scan copy called for has not been received. So, later reminder reissued by the registry to requisition the scan copies of the order sheets connected to GR case number so-and-so as directed by this court by the order dated 6/8/2024. Stop. The scan copies directed to be called for be placed before the court by the next date fixed. Based on 16th of December 2024. A copy of this order we brought to the notice of Registrar Division for doing the needful. Yes. Guwahati High Court. All right, MS so appears on behalf of Mr. H.K. Das. People.
Your Lordship, it's a petition under 11.6 for appointment of arbitrator from the panel of arbitrators of this honorable court. Now, Lordship had an occasion to hear me earlier also. Lordship, I am squarely covered by the judgment of Borpeta Agro Infra. If I may, can you please with your Lordship? My case is squarely covered by this judgment. Here the same issue came up, Lordship. And the issue was whether GM of the NF Railway was competent to arbitrate or to nominate an arbitrator. Now, in view of the amendment of the Arbitration Act, Lordship, in 12.5, this judgment says that no. And in conclusion, Lordship, it is, if I take your Lordship to the conclusive part, grounds for challenge, that is page 1313. When a person is approached in connection with his possible appointment as an arbitrator, he shall disclose. Now that he shall disclose in writing any circumstances such as existence, either direct or indirect, of any past or present relationship with interest in any parties or in relation to the subject matter in dispute, whether financial, business, professional, or other.
No, what is your grievance? That
Yes.
You don't agree to the panel projected by the railway.
I don't agree to that, because Lordship will kindly see that first I have issued a notice and
We'll hear you. Yes.
My lord, we are waiting for a long decision of the Honorable Supreme Court in the civil appeal, my lord. This Honorable Court by 8 November 2024 passed this judgment. After hearing the decision of the Chief Justice of India, PI 32, the Honorable Justice passed this judgment, my lord. But in the they made the conclusion that with these findings and observations as made by the Honorable Chief Justice, I summarize my conclusion as follows. Dispute resolution through arbitration encompasses two independent yet independent principle contextual freedom as party autonomy and the statutory obligation as duty constitute.
That is the judgment. That is the minority view.
Yes, madam. The last.
So therefore, the majority view of the judgment will prevail.
Yes, madam. In the last para, para 17, my lord, Lordship observed that neither public policy considered under the Contract Act or the Arbitration Act restrain the parties to the arbitration from maintaining a panel of arbitrators in a meeting. However, arbitration agreement enabling one of the parties to unilaterally constitute arbitral tribunal do not inspire confidence of independence and may violate the public policy requirement of the constituting independent and impartial tribunal. The court will therefore deny the agreement and hold them to be invalid if it is considered appropriate. The occasion for the court to examine the constitution of independent impartial tribunal under the arbitration clause, which arises when one of the parties make an application under section 1149 or 34, it is not permissible for the court to give an advance declaration that all such agreement to enable one of the parties to unilaterally constitute the arbitral tribunal would be void as per se. No two agreements are the
So
same.
what? Please sum up. Why are you reading
Yes,
the entire judgment? Tell us what is your submission?
There is an agreement between the parties, my lord. This cannot be, it cannot be violated, my lord. So as per
Is this the finding of the
Honorable
court?
Supreme Court, my lord.
Then what happens to the
Now the
majority view?
where there is agreement.
What happens to the majority view?
Yes, my lord.
What you are reading is a minority view.
No, my lord. As majorities are not mentioned here, my lord. The power to ensure the arbitral agreement is competent of the public policy. A requirement of establishing an independent impartial tribunal is always of the court. The appointed as an arbitrator to execute.
You have left out the majority view. That's what I'm
Yes,
trying
my
to tell
lord.
you.
Yes, my lord.
So the majority view is binding.
My lord, and
The judgment will have to be read.
yes,
The
my lord.
ratio is to be read in terms of the majority view.
Majority view.
What is the majority view?
I am reading this conclusions of the
You are
judgment.
reading conclusion of a minority view. There is a conclusion of a majority view, and there are conclusions, there are three conclusions. One majority, two minority, two separate minority view. You are reading one of them.
Yes, my lord.
So first you have to read the majority. Have you gone through the judgment, Mr. Bhattacharya?
No, Lordship, I'm very sorry. I have not
Please
gone
go
through
through
the
it and
judgment.
come back.
Lordship. Let Lordship give me 1 week time, Lordship.
Yes, my lord.
Lordship, however, I'd like,
You have trouble reading a judgment.
Yes, my lord.
Just imagine the trouble of writing such a judgment.
No, my lord.
can I have a copy?
As for that, accounting agreement, my lord.
Learned counsels will apprise the court on the latest position uh, pursuant to the delivery of the judgment by the Constitution Bench of the Supreme Court.
Okay.
Please the matter again.
After a week, Lordship.
Uh,
Matter has been lingering for a long
22nd, 21st of January.
21st of January. Lordship.
God bless you, Lord.
We have given you sufficient time to read. Both the counsels. Please come and apprise.
Otherwise, also, Lordship, they are referring to their contract agreement. In their contract agreement, the
You read
rank
the
is
judgment
vague.
and come. You read
Lordship.
the judgment,
Lordship.
then make a submission.
Lordship, certainly. Deeply obliged. Just tell me the citation.
Yes.
Had only heard the matter the other day where we had raised this plea of ergonomic whether third party raise are amended. In such cases, whether the sections of interference at the stage of appointment, section 11(6), my lord can be made. Lordship has in fact referred to the recent judgments in this regard. I have made a compilation, my lord.
There is also a judgment with regard to third party involvement.
My lord.
With referring to matters to arbitration. Whether
That is the
matters-
group of companies as well.
Huh?
That is the group of companies as well.
That notwithstanding third party right, after certain parameters, matter can be referred to arbitration.
Yes, ma'am. Yeah. In fact, the entire other judgments, my lord, the gamut has been, my lord, summarized recently in SBI General Insurance, 2024, July as well. So the possibility of exploring this, whether arbitrator will be appointed at this stage or not, the 11th a narrow compass is still there. So on the basis of the facts, my lord, as to how they reveal in this particular case.
Subject to the extent you can convince the court.
My lord.
But the law is
to appoint. Law is to appoint, my lord. Tilted towards appointment. Exceptional cases, my lord.
Only duty left to the court is to examine the existence of an arbitration.
My lord. And exceptional cases, my lord, where, my lord, the
The
four
issue-
parameters that are set out in Dictator.
Right.
That is
No,
the
but
narrow compass.
Vitras Olia also has been watered down in subsequent time.
Not exactly watered down because, my lord, in SBI General Insurance, the conclusion, my lord, I still find, my lord, in para 93, says therefore that as the position of Mayavati Trading and Dictatoria is that ordinarily the courts, while acting in exercise of its powers under section 11, will only look into the existence of the arbitration agreement and would refuse arbitration only as a demurrer when the claims are expressly frivolous and non-arbitrable. So the non-arbitrability part is there.
No. I think you should read further.
My lord, I'll tell it now. Because the issue number 2 was the finding on 11th day. This is the last error. Yes, yeah. I just read para 93.
Yes.
So the conclusion relating to powers, the extent of powers under 11.6. The third issue, my lord, is relating to interplay between arbitration agreement. The stamp. That's not our case.
We come to paragraph uh, 132 and 33.
No, better claims are fine part is there. So limitation is always a mixed between of law and fact, and therefore, probably my lord, the indication was that it should be left to the arbiter.
No, but then
The
you
plea
read,
of limitation.
then you read 133.
The first part, of course, it says that the inquiry is limited. Inquiry is limited. But then if we read 133 with 93, my lord.
No, you read only 133. So 133 clarifies that it is limited.
Yes. Only exception is that for 93, that
Right.
if they are ex-frivolous or non-arbitrable. So what is non-arbitrable? The four factors my lord are discussed in detailing together. One of them is the arga of the effect. Right?
Arbitrable, non-arbitrable has to be on the face of it.
Right.
Not arbitrable.
Why I say on the face
But if the whole effort of trying to decide whether it's arbitrable or not arbitrable.
how it is coming on the face of it.
Here there are two plots of land.
I had given lordship a sequence of events that had happened.
Yes.
In this particular case only, my lord, there is section 9 application 5 of state. In that application, my lord, what was contended is that the road has to be
No, in this map.
blocked so that
in this map, there's block 1 and block 2.
And block 3 and block 4.
Block 4. Now,
till 3 there is no dispute.
Petitioner land is block 1, 2, 3.
1 and 2.
1 and 2.
It used to be his land because after the development, my lord, it has several 130 owners.
Now his grievance is that
4 is illegally because he says that the adjacent block that I have used cannot be extended to the block 4. If that is so, my lord, in the section 9 application, they have sought to, my lord, Inzantas from entering into block 4 through this common road termination. Now, therefore, the rights of this person who are there in block 4 might be directly connected. Therefore, they are not being a part of this arbitration. Tomorrow, if the arbitrator finds that yes, this construction of block 4 is in violation of the order, the block 4 person, my lord, they cannot come and interfere in this arbitral award because they are not a party to it.
Have Have you referred that recent judgment of very recent judgment of the rights of third party? Yeah.
That was, I think, in respect of the group of companies, where I think we have done a case recently, where an agency was appointed or a company has a subsidiary. The subsidiary does conflict, then the question of the principal and the agent conflict, and therefore, in those cases, they can be seen as a single entity.
Still like to go through it.
In fact, today I would, with all due respect, I was having some trouble in the eye during the last weekend, so I could not read extensively, so I have made a compilation. I will share this with my learned friend also, whatever I have compiled.
I have a limited information, Lordship. Here, Lordship, my claim in the notice, Lordship, will go. It is only against the company or against them with whom we have an arbitration agreement, not with the third party. Prima facie, Lordship. Prima facie, there is nothing. We have nothing claimed for the third party. If we go from if learned friends,
He says that the dispute is with regard to the extra land,
not
which according to you, you did not give him the authority to
use.
develop.
No. Lordship, with due regard, Lordship, that is my grievances is that we have given a plot. They are saying that they are not they are owner of the building. They are owner of the land because land is owned by me, Lordship. So it is a joint. You can, Lordship, can refer it is joint partnership agreement, joint agreement, because they are the developer.
No. Where is the dispute? What is the dispute?
Dispute is that, Lordship, they are either the plot of land is in my name. Plot the
Which plot?
This where the existing this first plot, Lord.
First
Block 1 and 2.
Block 1.
1 and 2.
1 and 2.
Yes, Lord.
All right.
Then Lordship, what they did, that plot still exists in my name, land, and we have allowed them to construct building, Lordship. So by this way, they are the owners of the buildings. We are the owners of the land. The equation is fixed that land becomes we always become the owner, Lord. Now what they did, the permission was procured by us from the GMDA by saying that it will be like Lordship. We will construct 144 flats. We have procured permission. They have not procured permission. 144 permission for constructing building. We have procured. We allowed them to construct a building. The building permission was GMDA was not from the. And then what they did, they used this plot of land. They are using our plot of land, going to that adjacent plot of land, which is against the GMGA violation also. For that, we have availed all other legal remedies. These are all pending, Lordship. Here, my grievance is that we are claiming some amount that they have used this land in 2019 till the land was being sealed by the Section 9 application by the CJC judge. Till that period, we are claiming the amount. Only my grievances, we have nothing. We have claimed some amount. But that part, we have nothing, no third party. We have not claimed from anybody. We have claimed from them. Because they have violated the arbitration agreement. And my learned friend has admitted.
What we want to know, what is that area of dispute?
Area of dispute was our plot, not that plot of land.
What is that dispute? Why are you disputing? Why do you want the matter to be referred to arbitration?
Because they have used profits from the land which we are the joint owner by using our land. That is the reason.
They have used the profit to develop some other property.
Yes. By using our land, when we are the joint owners, Lordship. Technically, Lordship, we both are partners because land is ours, building is theirs. Lordship. So we both are partners, but they have not given us anything. So dispute is there, Lordship. So my learned friend is also.
They have not given you anything in terms of building.
In terms of using the road.
Using the
road, which block 1 and 2, because they have used it now. You use it going to the block 4 also.
You wanted exclusive usage of that particular road.
Yes, Lord. That was not road. Initially, that was being.
No. That in this map.
Lord. Map. Okay. Sorry. Yes, sir.
On this map,
Lordship.
there is a driveway.
Yes, Lordship.
Now,
Now, this was being this was not the GNDA map. This was being drawn by my learned friend Lordship for the understanding of this code, Lordship, maybe.
It is not exactly the building.
Building, but this is not the building permission. This roadway is not given in the building map, original map.
No. One, no, that this block 1 and 2
Yes, sir.
comprises of one plot of land.
Yes, sir.
Essentially.
Yes, sir.
Then 3 and 4 are two different plots of land.
No, Lordship. 3 also it is in the agreement, Lord.
There is your land.
Not, it was referred. We have allowed
that excess land.
That excess land we have allowed them to use.
All right. So 1 and 2 belongs to you.
Yes, Lordship.
3 was under your possession.
Yes, I have allowed them to
You
use.
have allowed them to use.
Which is in the arbitration agreement.
And then there is this block 4.
Yes, Lordship. Which we are
Now,
not
for
allowed.
all these 1, 2, 3, 4, the access is through the driveway.
Yes, Lord. Now driveway they have stated, Lord. It is our land.
How do you get into your road? How do you go into your block 1 and
Lordship,
which road?
1 and 2, this road. This is our plot of land. Road not. It is a first plot, Lord. It is entry. I don't know. This is first plot, Lord. It is,
What I want to
this is the first plot.
understanding is that this is one contiguous plot of land divided into different compartments by way of ownership. 1 and 2 belong to you, 3 doesn't belong to you, but it is under your possession. 4 doesn't belong to you.
No.
Now for all these land, what is the access road? Let us say block number 4.
Block number 4, no access. Earlier. Another way there is access. They have another way access. Now they are using, there is another way from the backside of the BT school.
You are agreed by the fact that your way is being given to the residents of block number 4.
4, yes, Lord.
For being used.
For being
That
used.
is the cause of dispute.
Yes, Lord. So we have only claimed from them, not from the.
You just have to build the road. They are not asking for building.
Malwa, the issue of whether this road is there, they filed a civil suit of. The civil suit, my lord, we have pleaded that this common egress and egress was always there. That suit got dismissed because the case was filed by one of the partners, not the partnership. Of course, that issue did not get decided.
This is an issue that can be decided by the tribunal, whether it is arbitrable or not.
My lord, normally, yes. But the way the dispute has unfolded now, because in the section 9, the relief they are saying
Because ultimately their claim in arbitration is compensation.
Yes, Lord.
My lord,
Not land or
that
building.
compensation can be given only when they say that this clause 9 has been violated. Clause 9 is that what is meant by adjacent land
that has to
is not clause 4. Therefore, my entire permission, if this is the interpretation that clause 9 does not mean that I can occupy block 4. The rights of everybody in block 4 is also affected because it has rendered.
How?
Because the entire construction becomes illegal then.
That is
The
not-
same finding, my lord, they won from the writ court, where they have alleged that the GMDA authorities have been connivance with us, given this building.
No,
They have filed FIRs against GMDA
no,
officials
whatever it may
and
be,
asked,
between you and them, there is an agreement.
my lord.
Now, in that agreement, whatever business you wanted to do, there is one provision that in case of any dispute matter should be referred up.
Yeah.
Now, you don't deny the existence of this agreement for the arbitration.
My lord, we say,
You don't dispute that the differences have arisen out of the course of business, which both of you have agreed to do by virtue of the agreement. Right? So therefore, whether you are required to, whether the dispute raised by the petitioner
arbitrable or
arbitrable, not arbitrable, whether these disputes can ultimately be decided by these two parties, or is the involvement of any third party necessary? That is the question. But from the documents available, does it appear to be that any third party will be involved?
my lord, the
Third party may
tomorrow the question of damages will come.
Third party may have a claim against you by whatever means they have a claim. Let us say hypothetically, I do not know, but hypothetically, you have given them this plot of land, showing them this particular road of interest connected, and they have purchased it accordingly. Today, if you say, sorry, tribunal or court has given an answer, given a verdict that you cannot use it, you have to use some other, or you find something else that for which extra payment or whatever needs to be done, then they may have a claim against you, because you have entered into an agreement with them. Not this partnership has not entered agreement with them. So prima facie, it doesn't appear that a third party right as such to prevent reference to an arbitration.
The very multiplicity of litigation between the parties is indicating, my lord, that there is an effect that goes beyond what can be decided in the arbitration. Because it has consequences, my lord.
Core issue is whether you are required to compensate him or not.
Yes. But then only if I
How
violate.
you want to compensate him?
No, my lord, if only if I violated the agreement, the question of compensation will come.
That's right.
Only damages will come only when there is a violation.
That's right.
That violation, my lord, if this clause is now read down as to that I cannot construct block 4, then the block 3 and block 4 are also affected, my lord. How? Because the block 4% in the other proceedings are saying that no, this common road was always there.
What I'm saying.
And they cannot now in the arbitration come and say that this road, common road was always there.
So you are trying to say that this is essentially a civil dispute. So until and unless the civil court decides, there is no question of
Either because repetitions are also pending.
who has approached the civil court.
My lord, one of their partners, and he had gone in a capacity of the own. In fact, this particular person also has come on his own capacity, not as the partnership partner.
Yes.
So he is no longer the exclusive owner. The landowners have now, after he has entered into the development activity, all the flat owners have to become landowners because they have a right. In fact, when they blocked our electricity connection, this honorable court therefore gave a finding that this kind of petition cannot be instituted. And blocking of this passage, etc., even this section 9 exemption was also listed on the very premises that because third party rights are affected.
So that's it. Regarding my learned friend, in section 9 application, we got their building was still lordship in the first instance.
Temporary.
Now, no, whatever the reason may be, then they came to the appeal lordship and it is still pending lordship.
Still is pending.
Lordship, here my contention is that I have lordship is posed to the my notice lordship. I have never claimed anything from the third party. And even third party, even he is asking.
No, you have not claimed. What is your claim? That is what we want to find out. What is your claim?
Yes.
What is your claim?
Claim is that they are using my that road.
So, is there any civil suit pending to
No.
To the effect that whether this is actually the municipal road or the road?
No, nothing. No, see, it is a prima facie lordship. Prima facie lordship. It is the admitted question from the agreement lordship that building that is our land. That means that lordship may go to the agreement lordship.
No, but Mr. Pathak says there is a suit pending for what?
It got dismissed, but one of their partners filed it because he
No,
has not filed it in compliance with the Partnership Act.
No, lordship. We have already
69 compliances.
69 count. That res judicata will also not come because it was not in the proper forum lordship because
Yes,
it is
course.
unregistered.
That issue is not decided.
Not decided, lord. Lordship, my friend is there. Maybe it could decide one.
That issue is not
decided. That we cannot go to lord.
All right, we'll post it next week. Since you said you have some I problem. We'll keep on 10th of December.
Lordship. Holiday, I think. Restricted. Then
all right.
Other matters.
Then
9. 9.
9.12.
9.12.
12 is Thursday, my lord.
12.
Nearing holiday, lord. Let it be on 9.
No, Lordship has already understood the crux of the matter. So they only now deciding
Lordship,
which way to go back. That would be convenient.
not on 2 to 6, but next week, I'm not able.
We'll keep it on 16, let us see, possible.
12.
16th.
Right.
16 December.
I'll put up in the comment.
Well, there are other matters fixed, so
9th,
Not
Lordship.
much time because Lordship has already
the much
Just
time,
with that
provided
concept.
the matter gets called up, because there are pattern matters fixed already well, for disposal.
We'll make it.
Or we can have it on 11th if you are available.
Yes, 11, Lord.
11th we can try.
Oh, yes.
All right, list on 11th. It's agreed to by the
Oh.
Learned Council.
Obliged.
It has been full movie. The department has been directed to dispose of the representation after giving a hearing to both.
Lord.
So,
The thing is that, Lordship, first thing is that the department has already considered the representation. After considering the representation, the impugned the order they have challenged hearing was passed. So again, if Lordship direct the respondent to consider, there is every possibility that the respondent will change their mind. Because already
where is,
yes,
what order was passed earlier?
Lordship. Lordship will find a page at 38. So Lordship will yes, 38. The order they have challenged, Lordship. This order, Lordship, prior to passing this order, this respondent Lordship has challenged.
You are the first wife. You are the first wife.
Yes, I am the first one. So Lordship, before passing these orders, the respondent submitted two representations.
You are entitled to pension now.
That I am getting, Lordship.
You are getting.
Lordship.
You are not sharing with her.
Lordship, initially, Lordship, some portion of amount of Lordship amount was given to her as per my instruction. I'm not sure. So now, after Lordship filing this writ petition, some dispute Lordship between these two families, and thereafter Lordship they have come before this court that since Lordship they were not serving notice, and since the department has already taken into consideration their representation, and this subsequent order, if Lordship, on the basis of Lordship's order, if they respondent again Lordship go by to reconsider their application, so there is every apprehension Lordship that their mind might be changed. First thing. Second thing is that Lordship, prior to filing their writ petition, whether they have there any locus standi to file a writ petition Lordship claiming 50% of their pensionary benefit, being their second wife. That law has already been settled by this division bench social Lordship that since the second wife is entitled only for maintenance through proper forum, not in writ court. So on that count also Lordship, their writ petition was not maintainable at all. Because if Lordship go by the prayer of their writ petition, Lordship will find what they have paid in their writ petition, Lordship will find at page 31. 32 Lordship is the first one relevant.
You come to page number 64.
Lordship. Page number 64 Lordship.
Yes, this is the part, penultimate part of the judgment.
Yes.
Read para 22.
We further hold that the family pension being payable to the eldest of surviving widow or wife would not mean that entire family pension so payable would be the personal property of the eldest of the surviving widow or wife, and the family pension so payable would be held by the eldest of the surviving widow or wife as a trustee for all such other persons who are entitled to the benefit of the family pension in terms of Rule 143 of the Pension Rule 1969. So it is clear, Lordship. I am also not saying that I am only the yes. Only thing is that, Lordship, since first thing is that in the writ petition they have filed. First of all, they have their no location to file a writ petition. Second thing is that, Lordship, she is also a government employee. So I am a Lordship housewife. So she has sufficient means of Lordship livelihood. So their second thing is that. And
You are a government employee.
Lordship. Contractual is Lordship since last 30 years she is working, 30 or 20 years Lordship working. So
But no pension. But no pension.
So she's still working, Lordship, getting
Working,
yes.
she's getting a salary.
Yes, salary. She's
no
getting her salary.
Yes. You are not you are not questioning her marriage to your
Yes.
husband. Both of you are wives.
Yes.
So she's entitled to a part of the
Part
state.
of the entitled. Part of the entitled, that's true, Lordship.
Huh.
So their remedy,
This is the view of the full court.
yes. And their remedy is not in the report, Lordship. Their remedy,
Whatever
yes.
it may be.
Lordship.
Their remedy may not be in the writ court, but that is not a ground to review and recall the order passed.
Because Lordship,
the order was passed keeping in view this judgment. The judgment says the pension rules will follow.
Yes.
But it has also given a view that having received the pension, it is not entirely yours.
Yes. So,
if we record your submission here that you will share a portion of the pension, and we close the matter.
No, Lordship may just recall the first order, and Lordship may give us an opportunity to file our application in the repeat.
To what effect?
Because Lordship, first thing is that Lordship thing is that before approaching a court, the person must have his right to approach the court. That first issue.
His right is recognized under 22.
Under 22, Lordship, not in writ court, Lord.
Says who?
She
has a right. She has a right recognized, which is recognized under para 22.
Para 22.
That she is entitled to a part.
Para 22 recognized only Lordship that she is entitled for pension benefit.
No. She is entitled to a part.
Yes.
But subject to the rules.
Yes.
Governed.
The
rules having said that it will go to the eldest surviving.
Yes.
Will not otherwise deprive her of a portion of that.
Yes. Lordship, the relevant paragraph of your Lordship's judgment.
Para 22.
No, para 22, Lordship, I am considering your Lordship findings that para 20 has given the right to this second wife also to get pensioner benefit. Another pensioner benefit from the first surviving eldest wife, Lordship. That is clear. First thing is that, Lordship, what the division bench has held, that pensioner benefit has to be, Lordship, she has to collect that pensioner benefit to proper forum, not in first writ court.
What forum?
Forum, Lordship, to claim maintenance as a maintenance. That will not that will come as a maintenance. That will go. She has to go.
You are bound by this judgment.
Yes, the judgment has said.
If you want to.
No, judgment saying so, Lord. The judgment is still saying so.
Oh, definitely.
Yes. Judgment saying so that to claim the second to claim pension by the second wife, writ court is not appropriate. They have to approach the appropriate forum. First thing. So they didn't have any right to approach this honorable court by writ petition. First issue. Second issue is that, Lordship, they have suppressed the fact because prior to passing the impugn order that they have challenged the writ petition, the department has considered two representation, Lordship. So once their representation is disposed of, and the speaking order, that impugn order was passed, how Lordship, if Lordship after passing Lordship's order, there is apprehension that since court has directed, they may change their mind. And if they change their mind,
it is up to them.
Up to them. That is why, Lordship, since they have already considered,
we have already delivered a judgment.
Yes.
You have filed a review.
Yes.
Saying that this needs to be reconsidered.
Reconsider.
Now, reconsideration for what purpose?
Reconsider in the sense that
this direction to reconsider, direction to the authorities to dispose of the claim is not upon hearing only the petitioner or other state council or anything. It is in view of the law laid down by the full court.
Full court.
So the full court says eldest wife is a trustee.
Yes.
you are entitled to look after. In case you don't get,
Yeah.
there are forums you go.
Okay.
State authorities are not required to pay them directly.
Yeah.
But unless state authority on their own volition
Okay.
decides.
Yes. Now the question of own volition will come. So lordship may come to page 9 that I have quoted the paragraph. Page 9, lordship, I have quoted the paragraph.
Then?
Lordship. Just I am reading the paragraph, lordship, that I have quoted in page 9.
Page?
Page 9 of my review petition.
9.
Lordship.
Yeah.
This was the same judgment, lordship, Genufa baby. We also provide that in the event any such or other persons who are entitled to the benefit of the family pension in terms of Rule 143 of the Pension Rules 1969, including the second or further wife, in a case where the parties are governed by the Mohammedan law, are not appropriately maintained by the eldest of the surviving widow or wife of whom the pension would be paid, the remedy thereof would be to make a claim for maintenance in appropriate form under the law and not a claim for payment of family pension by state authorities directly to such persons. But however, in a case in the state authority or their own volition are of the view that under an acceptable circumstances, the authorities are agreeable or required to pay the pension separately to any such member of the family of a deceased employee, this judgment may not be constituted to be an absolute bar on such separate payment. So, Lordship Court has already made clear that if the second wife has the right to claim maintenance, she is not to approach the direct authority to give share of her pension. She has to approach the appropriate forum. Appropriate forum here, what I have understood, Lordship, is the trial court, the under 125, she can claim a petition that I am not properly maintaining, so I may be given maintenance. So this is the way, and they have direct.
Then what meaning do you ascribe to the later part of the last few lines of the paragraph?
Yes, but however, in a case where the state authority are on their own volition, that part has already gone lost because the state has already passed the order considering their representation. So if Lordship again direct the concerned authorities to reconsider their application, then Lordship the situation makes sense. Because
if it changes, it changes because
no,
that
Lordship,
is the liberty
that's
granted
one
by
thing,
the
Lordship.
authority.
That is why I am saying, Lordship.
You may be agreed, you may challenge that order.
Then Lordship, it will just create the multiplicity of the proceeding. Nothing will move.
Maybe.
But Lordship,
what we have directed
yes,
is reflecting the view of the full court.
Yes, that is why I am saying. Full court has said.
Full court view.
Yes.
Full court view. We have reflected and remanding the matter back to the authority to examine.
Yes.
If the authority decides that okay, same order is to be restored, maintained, it is to be maintained. If they think that no, we can change it on our own, it's up to them.
That is why the question has come, Lordship, because the respondent already considered their case.
Whatever it may be.
No, so
is there a bar for the court to direct them to
that's
reconsider?
what I have understood from the judgment, Lordship. If Lordship on the respondent on their own position doesn't consider their application, then they have the right to approach the.
We are not forcing them to consider. We are only asking them to reconsider. That's all.
Because Lordship, the first thing is that to approach this noble court as a writ petition, first they have their right to be a aggrieved person.
The court has not directed a payment of pension to them.
That's true, Lordship. But court has entertained their writ petition. Lordship, kindly recall the order and give me an opportunity to file our objection. Then Lordship will.
What objection?
To Lordship their writ petition.
Whatever
because,
you want to do, you do it before the authority.
No, Lordship, the first thing, Lordship, that they have their no local standing to approach this noble court.
They approach this court seeking a direction to grant 50%.
50 years. That they have that right they doesn't have.
Right.
Because
yes. Therefore the court did not order them.
Because the court has
did not direct that you pay 50%, 20%, 30%. That court merely said you consider it the light of the judgment. That's all.
Now Lordship, thing is, that is what I am saying. Before passing the order by the respondent.
Whatever you are urging here, you urge before the authorities because we have directed that they should be reconsidered
because
in the presence
without any right, if they are getting their relief in this court, then Lordship, I will be prejudiced.
What right?
Because they have approached they doesn't have any right to approach this noble court under 226.
They don't have a right.
Then Lordship, and then the simple issue is that Lordship, since they doesn't have any right to approach under 226, because
they don't have a right.
Because the paragraph 23 says
Appropriate forum.
appropriate forum is not the lordship this report.
Appropriate forum has it been, has the report been excluded?
But lordship, yes, language says so, lordship. Because they cannot directly.
Appropriate forum.
Yes, appropriate forum, lordship.
Under law.
It may be a pensional tribunal that may be done, but
It
not.
may be there, but does it say that appropriate forum excludes the report?
No, lordship, that.
Under what
No, lordship, that is not saying.
interpretation have you brought this?
No, lordship,
analogy?
the appropriate forum regarding maintenance, the word maintenance has been used.
Mr. Counsel, don't interpret for the sake of interpreting. Do it properly. Say that appropriate forum will exclude.
Yes.
Give us an authority.
I am not saying that lordship this
So
code is.
what are you saying?
But thing is that lordship, apparently lordship, maintenance code is not a record is not a maintenance code.
All right. Heard. Senate Council dismissed.
And one observation, lordship, may just record my submission regarding
Any more
judgment.
submission will impose cost
Lordship, this honorable court, this.
and direct the authorities to deduct it from the pension.
It's a fine, lordship, but lordship may remand back the matter to the right.
No remanding. Dismiss. We'll pass the order. Not maintain him. No review is maintainable.
Lordship.